Yeah, I do.
All right, good afternoon, everyone. We have a couple calendars to work through. Let's see who we got online. We'll start, they're both for 1 o'clock, but we'll start with the inquiry calendar. Deputy Gordon? Can you get Deputy Gordon just to poke his head around the corner? Yeah. You can just wipe the mustard off. Hey, that's okay, you're good. You don't have to come out here. You got a little bit of sandwich right there, yeah. Ms. Honholt is here. Mr. Davis is here. I don't know if Tracy Jones is in custody. Tracy Jones, male or female? No. Male, okay. Mr. And Jason Rhodes.
Not here.
He may not have made it. That was this, DeKalb it's actually someone from the sheriff's office here who's being high made. Yes, and then we got Beck. Okay, great. I'm happy to handle these in any particular order. Mr. Abate, I got word from Ms. Nelson about the family, so we'll work through that. Any preference on how we do these things?
I would like to do Ms. Honholt last.
Done.
If we could do, are we good with doing Mr. Davis first? I just need to speak with him and go through the sheet.
Sure, if you're gonna do that, or I guess you have everyone.
Yes.
Oh, great. So what if you go talk with Mr. Davis while we talk about Mr. Beck?
Hey, Judge, Mr. Beck is more for a motion to set aside inventory bond forfeiture. I don't believe that it already comes from on the line. I had a chance to speak with the state. I think the state's going to consent to her.
Okay, I'm not sure I am, so that's why we need to talk about it, just given the number of cases he has. But we should definitely have a conversation about it. So if you want to come around, and then we'll see. I'm hoping they'll bring Mr. Beck out while Ms. Wood is back there, but let's see.
Do you want me to come to the?
Or at least be at the defense table. Make yourself comfy there, and then. And you are Ms. Williams, or is it Mick Williams?
I'm Michelle Williams from the state bar, just covering for.
For Ms. Davis. I recognize you weren't Ms. Davis, so it's Williams. And Ms. Davis kind of got you up to speed as to what she's got today, or?
Yes, Your Honor. I think I'm mostly up to speed. I may have some questions.
It's all good. We'll work through it.
Thank you.
We will figure it out. Ms. Madden, the situation with Mr. Beck was that he missed court, but he missed court on all 4 cases.
I don't believe so, Judge. I was looking at Odyssey because it looks like all of the cases happened in 2022. They weren't indicted until 2024.
Right.
I think 3 of them were in non-complex, if I'm not mistaken, and then they end up being transferred. He did make 2 court appearances from what I can gather, and speaking with him and looking at Odyssey, they were both via Zoom in non-complex. And then I think when all of the cases were transferred to you, he was placed on another plea and arraignment calendar.
That's what he missed.
And that's where he missed. Now, according to him, he did say that his address changed, and they did indicate in Odyssey, in one of the notes, it looks like, I guess they had sent notice and it was not good notice for the attorney or for the defendant. He indicated that at one of the Zoom appearances, I don't know if it was told to the attorney or told to the clerk, that he did update his address, but I didn't see anything filed showing that his address was updated. But he said that normally his attorney would just send him a Zoom link, but I don't even know if that was an option for plea and arraignment when it made it over to you. And I know he has a lot of cases, but it looks like, I think several of the cases were direct indictments. So I don't think it was a situation where he got out on bond, then picked up, I think they were investigating him and then issued.
I think you're right, because I saw only 2 arrests across 4 cases, which says to me some direct indictments were in the mix. When you refer to the attorney, Mr. Smith was his lawyer pretty much until you got involved, or a bunch of lawyers?
I believe so, but then it looks like a motion to withdraw was filed. My client indicated to me he didn't even realize his attorney had withdrawn from the case until he was arrested. So
How did you get in the mix? His family hired you?
family just reached out to me about representation. He was actually in Floyd County and I was handling a case in Floyd County, and he was just like, I have cases in Fulton County. That's when the hold popped up. But he wasn't even aware that he was in bench warrant status.
Okay, and what's the situation in Floyd County?
It was probation. That's since been resolved. We actually reached out to your litigation manager when he was still in Floyd County to try to see if we could do something with this.
I remember this, and I said he needs to come
Need to
here.
come, exactly.
So what are the charges out of Floyd County?
I'm not representing him in Floyd County. I think.
Oh, okay. Pardon me? You would know if he was on probation.
Yeah, he kind of still is. He's on a first confirmation.
First offender.
And it's for death by taking.
That by taking. And
I was gonna say that.
when was he sentenced in Floyd?
August 31st,
8/23. So that's after, these are all 22 events, I think. Certainly the most serious one, the robbery one, is from 22. Ms. Madden, we've been through several prosecutors since you got involved with the case. Did you ever have a chance to engage? Ms. Dilligard would have probably been the one on watch when you were first saying, hey, Floyd County, maybe we could work everything out. I'm just curious if you and a prosecutor ever started talking about, what are we going to do? It's 4 cases.
I did reach out, but have not been served with discovery, so.
In any of the cases? So when it was, because it wasn't yours, when it was,
No.
the 3 that were in non-complex, you never were involved.
I was never involved with those. So I did reach out to prior counsel to try to see, because I know that's always their preference, and I haven't been able to get.
Anything from Mr. Smith? Okay.
Yes. So, and I'll be honest, Judge, it's kind of been low on my radar. He got transferred to Fulton County and the family called me and said, hey, he's in Fulton. So I immediately tried to get him on a
He
counsel.
was stuck otherwise. What were you going to do while he was serving time on a revocation in Floyd?
I don't want to misrepresent anything to the court, but I believe so. I think that's what he was in Floyd County for. So he resolved his revocation matter. He's still on probation, is my understanding.
Yes.
But now he obviously has all of these open.
Okay.
cases.
But the actual criminal allegations predate his sentence. So these, I don't think, would be bases to revoke the Floyd County case. What was he revoked for?
Basis on a technical violation.
Okay. And how much time is left?
Because his probation was told, so I'm assuming he was supposed to on at some point. So, his new end date is March 23rd or 27th.
Okay. So he's got a year and a half left-ish. Are we able to bring Mr. Beck out, or because Ms. Wood is back there? Okay. Are you able to tell whether he absconded?
Actually, yeah, because,
So like,
No, he can sit right. Whatever is easier for you with this setup.
I'm good. How are you?
I think so.
I have to ask the sheriff. He said, can he have a meeting? I didn't think so. I just.
According to the tolling order, there was a field visit done August 9th of 2024. And the judge of Fort County signed a tolling order, August 13th. So, look again.
I'm gonna ask Mr. Beck because he's here. We'll figure out what we can. Good afternoon, Ms. Rivers. Are you ready to do some takedown?
Yes, I am. Good afternoon.
Great. Well, let's get started. We are here with Demetrius Beck, who has not one or two, but 4 cases. All are, well, 3 of them are 2024 indictments. One is a 2023. He's represented by Ms. Madden, who is newer to the cases. Mr. Beck, I'm Judge McBurney. Nice to meet you. I think originally Mr. Smith was your lawyer on at least the 3 cases that were in non-complex. I say 3, there's not, 2 of these can't have been in non-complex because you've got 2 robbery charges and that doesn't go to non-complex. So I guess it was your criminal damage cases that were in non-complex. And I bet your newest one got transferred to me by some other judge, and new is all relative. But Ms. Madden is now your lawyer on all 4 cases. And it sounds like recently you were in custody in Floyd County.
Yes, sir.
Can you tell me why you were locked up there?
Well, I'm on probation there and I'm actually banned from the county. So Mr. Smith, my previous attorney, when I was released from there, he didn't fully explain to me what I was supposed to do when I was released. So they violated me for not reporting because I was supposed to went to their field office in Rome before I left.
Yep.
He didn't fully explain that to me, so I didn't know.
You thought because you were banned, you should not go to Rome.
No, they talked because they transferred.
Yeah.
And so, but I was supposed to go there first.
Yeah.
He didn't explain it to me in full detail. Maybe he misunderstood. I'm not sure.
Okay.
They violated me for not reporting.
Did you try calling probation to see what the deal was, or?
I mean, I didn't know I was supposed to go there. Like, as far as on my end, everything was tracking. And then.
Did you report to a different probation office?
Yes, it was in Douglas County.
Okay, that's where home was for you?
Yes,
And you went to probation in Douglas?
yes.
Oh, okay. How long did you get revoked for?
10 months.
10 months. All right, Floyd County it is.
Judge, he does have a Douglas County address. That was the updated address that he gave to my office.
Okay, and if I look at the most recent case, there's not a change of address form. Got a Hampton address and an Atlanta address, though the Atlanta address is a
Yeah, that's the address.
That's a hotel.
And I have, and depending on what the court does, obviously, I do have a change of address form with his updated address in Douglas County. So that
Okay.
would be where he is residing.
Great. Well, I'll want to file that anyway. So someday he's going to be out. And so we ought to know to what address do we send things and what is that address?
It is 7-3.
Oh, you don't need to tell me on the record. You can hand to me. If you don't, we have a form or you may have already filled it out.
I have them, Judge.
Great. I meant, is that his mom's house or his uncle's house or his own house? That's your mother's house. Okay. And she's willing to let you stay with her?
Yes.
Okay. All right. Who is it who Ms. Madden gets deployed? Is that grandmother or mother?
That's his grandmother, Judge.
How old are you, Mr. Beck?
I'm 33.
How old would your grandmother be?
My grandmother, mom's 51, 52. My grandmother's like maybe 69 now.
And she's getting deployed overseas?
She did active military for about 40 years, 40 years, and now she just goes overseas.
I think she's a
and does
contractor.
Contractor work.
Wow.
Mm-hmm.
What does she do?
She works for the Department of Defense.
Right. That's the military part, but is like,
She just works in the office. She sits behind the desk.
okay. That's just that's a great age to be still working.
It is, and I've talked to her. She's very spry, Judge.
I have no doubt.
And very involved.
Yep.
She's the one who actually retained
I was going to say, she's the one who tracked you down.
Yes.
So she's serious about it. Okay. Is she stateside now?
She's still in Jordan as far
She's
as
still in Jordan right now.
All right. that's far away. I'm also trying to figure out where we are in the process, whether he's even been arraigned, but I think.
It looks like he's been arraigned on all of the cases, and I think his previous attorney, the case that he wasn't arraigned for, it looks like a waiver of arraignment was filed. I know it was like in case management and non-complex before it was transferred.
Right, but the most recent case, the one ending in 641, there is no arraignment yet. Right, there's not. You filed an entry, but we didn't ever have, as far as I can tell, an arraignment. There's certainly not a waiver of arraignment. So I'll need you to file, assuming you all want a waiver of arraignment, file one of those in the 3641, and I'm checking out the 2194.
It looks like there was a waiver of arraignment that was filed in the 2194 on 6/26/24. But that's fine, Judge. I'll make sure waivers are filed in all of the cases.
There is, you're right, in 2194 there was, but you have a lot of cases, Mr. Beck. There wasn't. So if you file one in the 3641, then I think what we'll do is, just because you are, relatively speaking, new to the case, get a scheduling order that will apply across all four. I know that there's been scheduling and the first two may have gotten far along, but you need discovery in all four, and relying on Mr. Smith to get that, I think, is just going to frustrate everyone.
Yes, sir.
And so the scheduling order gives the state a deadline to get you discovery in all four cases, and then a separate deadline for you to file motions that might require an evidentiary hearing. And then most importantly, a final plea deadline, so we can figure out what's going on. And is this a case resolvable, are these cases resolvable short of trial? All right, enough about that. Why don't we get on the record in terms of your motion, and we'll limit it to the 24 SC 003641. It applies to all four. But Ms. Madden, if you want to share with me why you think the bench warrant ought to be set aside for Mr. Beck.
Yes, Your Honor. Just a couple of things. It looks like, again, these are all cases from 2022, so they were rather old cases. They weren't indicted until 2024, but this wasn't a situation where he just never made any appearances in court at all. From what I can gather, when the cases were in non-complex, it looks like he appeared at least twice remotely via Zoom. And again, the address at the time, he did change his address, but at least according to my client, when I've spoken with him, he indicated that during the last Zoom hearing, he indicated that he had a new address, and he thought that, and again, there is no change of address that's on file, so I don't mean to misrepresent anything to the court, but he believes he either told his attorney, or I don't know if something was put in the chat, but he said he did give an updated address at that time. It does look like there was another court appearance that was scheduled, and there are notes in Odyssey that indicate that they weren't able to have proper notice to either counsel or to the defendant. He's indicated to me that he never received anything in the mail, that he didn't get any correspondence or anything from his attorney, but it looks like when he did miss arraignment in July of 2024, his attorney filed a motion to withdraw and was released from the case very shortly thereafter. But he's indicated to me that, any missed court appearance was completely inadvertent. He's otherwise not made himself available to the court. Obviously, he's been in custody in Floyd County dealing with the probation matter, but we're hoping that we can get him out so he can participate. I mean, he has 4 cases that he's going to have to resolve, participate in his defense. He was working, Judge, prior to getting arrested. He was working as a project manager for Capstone Logistics. I don't know, frankly, if that job is going to be still available to him because he was in custody for so long in Floyd County, but he's hoping that he can be able to get back to work and provide for his family. He does have a high school diploma. He does have 2 years of college at Talladega College. And all of his family, for the most part, lives here in Georgia. Again, his mother resides in Douglasville, and that's where he would be living if the court would allow him to be reinstated on bond. I don't think that the bonding company has gone off on the bond, so I think if the bench warrants are lifted, he would be able to be released on his original bond. And I think I stated this previously, but just for the record, this wasn't a situation where he picked up 4 consecutive cases, like he was arrested and then got arrested again. From what I can gather, at least on 2 cases, maybe 3, they were direct indictments. So there was an initial arrest and then warrants were issued later. So we would just ask the court to consider lifting the bench warrant. Like I said, this is something that we tried to resolve even when he was in Floyd County. So he's been aware that the warrant was outstanding in Fulton once he was arrested in Floyd. And then immediately his family reached out to my office to hire me to try to get this resolved.
All right. Ms. Williams, I know you are filling in for Ms. Davis, who would normally cover this, but this is a particular set of cases that would be brand new to her as well, in that Mr. Beck has not really been on our radar for a while because we couldn't track him down. And then he was in Floyd County, as we heard, for 10 months. So really the narrow question is set aside the bench warrant, don't set aside the bench warrant. And it's a little hard to recreate what the situation was, but I'm curious to hear the state's perspective.
Thank you, Judge. First of all, do I need to do anything so that the light is on here, or are we good?
If it's green, it's good.
It's nothing.
No light.
Okay, it should be on. Okay.
Okay.
Judge, so as we've been talking, I've looked over the docket for all 4 cases. I believe in the case that is docketed as number 1 on this on the add-on calendar, which ends in 9421. I believe there was a scheduling order sent out around the time of the very infamous hack that happened. So that may explain something about that. As far as the other 3 cases, there is I even have some questions about which ones were direct indictments and which ones weren't. It does seem as though Mr. Beck is being very forthcoming about his address. It seems that he has a lot of family involvement. So of course, we will defer to the court, but maybe if we do get that new address, change of address filed, that may be a way to clear all this up and allow the state to serve discovery and try to resolve the cases.
Okay. Well, I appreciate your candor on that one. I'm trying to recreate some of this as well. It's a murky document flow.
Yes, and Your Honor, some of the dockets have almost a 2-year gap in them.
Yep.
So that's plenty of room for confusion.
Yep. Just looking to see the last notices that went out. One. Mr. Beck, anything you want to tell me about you and why I should think you'll come back to court when we next have court, if you are put back on bond?
Basically, as my attorney stated, it's not like I was running from it. I did attend multiple virtual hearings before these that were said that I missed. And the ones that I missed, from my understanding, were virtual hearings. All the ones that I attended prior to those, he sent them, my previous attorney, he sent them to my email. For some reason, the one that is saying that I missed, I never got the email. It never came to me. When I reached out to him to find out, he kept saying he couldn't find it. He don't know what happened. I spoke to the owner of the firm. He told me if I felt like it was any wrongdoing that I could sue them, that I could sue, stuff like that. But like I said, it wasn't a situation where I was just trying to run. It was just I don't want to say negligence on his behalf, but it wasn't negligence on mine, if that makes sense to you.
Well, it kind of does, except it's your job to keep your address updated. But maybe what you did was give it to your lawyer and you thought the lawyer would take the next step. It seems like the most recent things that we were sending out to you were going to an address at the Courtyard at Maple. Was that a place you stayed for a while?
I was arrested at, that was my address at the time,
Okay.
50 Maple Street.
Yeah, what is that, an extended stay Courtyard or?
Oh, that's an apartment.
Oh, that's so it's not like the Courtyard at Marriott. That's just the name of
The apartment.
got it. So you had an apartment there, and you got arrested there, but you got arrested back in 2022.
Right, so when I got arrested there and I sat in here for 90 days, when
Yep.
I got out, basically the owner of the company was basically like, they didn't want me to stay there anymore.
Okay.
Due to how I was arrested there.
Okay, it's not a good look for them.
Exactly,
Yeah.
exactly.
So then you got a new address, which was,
I went back to I started back using my mom's address.
okay. What about this address in Hampton? Did you ever live in Hampton?
That's my girlfriend's address right now.
Okay, is that still your girlfriend?
Yes,
Okay, does she still live in Hampton?
yes.
But that's not where you're gonna stay.
I mean, I spend a lot of time there, but I want to use my mother's address because she's going to make sure that I don't miss any mail. Like her and my grandmother, they don't play about stuff like this. So
I don't get the sense your grandmother plays about much, and I really wish she was here, because if she was here, I'd just say, make sure he comes to court each time. But she's in Jordan. Yeah.
Judge, I can attest to that again. And I will say this, the family has hired not one, but two private attorneys to handle this. And, you know, I'm not the most expensive, but I'm not cheap either.
You are not.
So, I mean, that's a substantial investment, you know, for someone who, I mean, if he wasn't planning on coming to court for his family to sacrifice, so.
Okay. All right. Mr. Beck, what I'm going to do is reinstate, well, I'm going to lift the hold that I put in, but I'm going to amend your bond to add an ankle monitor requirement. It's going to be paid for by the county and it's only 6 months. It will come off well, it doesn't pop off, but if in 6 months it's still on you, and I haven't in a written order said it needs to stay on longer, you'll be able to get it removed. You don't even need to ask me because the bond order will say this can come off after 6 months. Thank you. And if you resolve your cases before then, it can come off. And I'm adding that only because it's a little funky, this setup, 4 cases and switching lawyers and where are you and where are you not? And while your grandma is passionate about it, she is 7,000 miles away. I won't change the dollar amounts. You're not going to need to put up more money. I'm just modifying your bond to include the electronic monitoring provision and pretrial supervision because they'll let me know if there's an issue. And otherwise, and then we'll need to have the address where you stay is the address, and Ms. Madden can well, I'm going to have it because it's in the change of address form, and that needs to be where you stay. I'm inclined to start with a curfew, which means by time X, you need to be at that address, but I don't want to interfere with your ability to work. And if when you get out, you haven't been out for a while, you seem pretty confident your girlfriend wants you to be able to visit her down in Hampton. If that turns out to be true and that's a place it makes more sense for you to stay, we can always change the curfew. But I think we'll start with you being at your mother's house. And for now, I'm just going to make it a 9 p.m. to 7 a.m. curfew. Happy to move that around. If you get a job and you got to work till midnight, as long as your lawyer can document it, look, here his hours from his supervisor, we can move that curfew around. And maybe we toss the curfew after a few months. Mostly, I want to see that the case goes forward, and when you need to be here, you're here, whether it's on a screen or you're here in person. And the more comfortable I get with that, the less intrusive we can make the bond.
Yes, sir.
Does that make sense? Ms. Williams, anything else you'd want to see added to the bond?
No, Your Honor, the ankle monitor is a great addition.
The one thing I don't know, you have 4 cases, and so I'll try to figure out how those orders work. You don't have one bond across all 4 cases. But again, I don't intend for anything I'm doing to require more money to be laid out for those bonds. But I may have to modify 4 bonds, so that you can be released on each of the 4. Do we know that there is a bond on each of the cases? With direct indictment, sometimes funky stuff happens.
Judge, I will make sure before I leave.
Okay.
I think there is a bond on everything, but I don't want to get a call tomorrow indicating that there's a problem.
Right.
So
Well, but we don't need to reconvene all of us in court. If there is no bond, I'll set a reasonable bond, but we may just need to be in communication via email. And so when I say there may not need to be the outlay of any more funds, if because it was a direct indictment, we've got a case where Mr. Beck is in no bond status. That doesn't mean there's a warrant for him. The DA's office sometimes does direct indictments without a grand jury warrant. Well, there's no bond, and so we'll have to set one. So Ms. Nelson and I will look at the 4 to make sure there's a bond in each. If there's not, then we'll just need to agree what that bond looks like. But I won't.
I'm happy to stay and make sure.
If you'll do that,
Yes,
that would be great.
That's taken care of.
And it does appear that there may be at least one case with an added charge.
Okay, meaning when he was released at prelim or whenever it was, it didn't have criminal damage, but when it was indicted, something got tacked on.
Yes, Your Honor.
Okay, all right, all fixable. Electronic monitoring and stay at mom's.
And Judge, do I need to prepare those orders or is that something that
You do not. I'll do the orders. You need to do the change of address form, get that to me. We'll make sure it goes into all 4. And then if you would check all the charges to see, there actually is a bond in each of the 4 cases, but the bonds don't apply to all the charges.
Okay.
We'll figure out how to fix that.
Straight today.
Ms. Williams, anything else from the state?
No, Your Honor.
Okay. Anything else, Ms. Madden, on behalf of Mr. Beck?
No, Judge.
If you,
I know we have to do the scheduling order. Is that something that I'm going to be provided with today or we will just get that by email?
it will be e-filed, and so you'll get it through the e-filing system. Before you can leave, I need from you the change of address form and a waiver of arraignment in the 3641 case.
I wrote that down, Judge.
Excellent. And we've got a waiver form here. So we've got all the paperwork. You just need to fill it out.
Okay, that sounds
All right.
good. Thank you so much.
Mr. Beck, any questions?
So I'm just listening to everything you just said. So how long would I have to wait before I can get released?
You have to be fitted for the ankle monitor.
Right, I know they have to bring it to me, right? Yeah.
Yeah, the ankle monitor will come to you. You don't go to it.
Right.
The answer is it depends on whether your family needs to put up more money. There may be some charges for which you never were given a bond, and I will set that bond, but it's not going to be 0. And so your family might need to put up 500 more bucks, or I'm making the number up. Don't quote me on that. As soon as they can post that, then you're good to go. But of course, all this paperwork has to happen first, and you have 4 cases. So if you are still in jail and it's next Wednesday, call Ms. Madden and she can reach out to my office to say, hey, is there something else Ms. Madden can do? But we hope to get through the paperwork, just times 4.
Because I'm going to stay here and make sure all the paperwork is done. Okay.
Did that answer your question?
Thank you, Judge.
You're welcome. That answered your question?
Yes, sir.
Okay. All right. See ya. Ms. Wood.
Yes, sir.
Are you ready to go on Mr. Davis? Let's do that. Is he okay being at the podium or should he? Okay. And we're pleading to the -01 case?
Yes, Judge.
I think they heard you the first time.
Mr. Body's gonna ask you, but if you have any questions, just stop me, okay?
Okay.
All right, look this way.
Let me know, Mr. Body, when you're ready. Okay. Then let's get on the record. This is 24 SC 006 492-01, State versus Demetrius Davis. Mr. Davis is here in court with Ms. Wood. Mr. Body is here for the state. Good afternoon, Mr. Davis.
How you doing, Ms. McBurney?
I'm okay. You okay?
Yes, sir.
All right, Mr. Davis, Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. Here's how it's going to work. In a moment, Mr. Abate, who is the prosecutor, is going to put you under oath, and then he'll ask you a bunch of questions. I need you to listen carefully to his questions and answer them to the best of your ability. If at any time he asks you a question that doesn't make sense or confuses you, will you let me know?
Yes, sir.
If at any time you need to take a break, will you let me know?
Yes, sir.
Okay. This is a serious plea, so I need to make sure you're understanding what we're talking about. You'll tell me if something is confusing or you don't get it.
Yes, I will, sir.
Good. All right. Then, Mr. Abadi, when you're ready.
Davis, you'll raise your right hand. Solemnly swear or affirm that testimony not given in the matter before this court will be the truth and the whole truth and nothing but the truth, sir.
Yes, sir.
Okay, and you're just gonna need to speak up a little bit louder.
Yes, sir.
Okay.
And you don't need to, if you can belt it out, you don't need to lean over. But if you're going to be quiet, you do need to lean over each time you answer. Okay? But go with outside voice.
Yes, sir.
Okay.
Put the microphone in front of you.
Oh, thank you, Ms. Rivers. I'm sorry.
Thank you.
Mr. Davis, if you will state your true, correct, and legal name for the record.
Demetrius Davis.
Will you spell your first name for the record? I know it's spelled different ways.
How do you spell your first name?
Demetrius.
IUS? I know, I think it's wrong here. Is it IUS? How do you normally spell
Do you normally spell your first name Demitrus?
Do I normally spell it that way? Yes,
How
sir.
it's spelled? Yes.
That's how it's spelled.
Okay, so the correct spelling of your name is Demitrus. Right?
Is that correct?
No.
Is there an extra I after the R?
Yeah, it's a I.
Okay, so there's an I after the R.
Okay, so the correct spelling of your name is Demitrus.
Yes.
Okay. And sir, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Okay. And is there any medication that you're given on a daily or you take on a regular basis that you've not taken today that would affect your ability to understand why you're here?
No, sir.
Okay. And how old are you, sir, and how far have you gone at school?
I went to the 11th grade.
How old are you?
I'm 38.
You're 38 and you went to the 11th grade.
Yes, sir.
And are you able to read, write, and understand the English language?
Yes, sir.
Okay. And do you understand from speaking with your counsel that you are charged with the following offenses in indictment number 24 SC 006 492-01? Count 1, murder. Counts 2, 3, and 4, all felony murder counts. Count 5, kidnapping with bodily injury. Count 6, false imprisonment. Count 7, aggravated assault. Count 8, aggravated sodomy. Count 9, possession of a knife during the commission of a felony. Count 10, rape. Counts 11 and 12, both aggravated assault counts. Count 13, false imprisonment. Count 14, possession of a firearm during the commission of a felony. And then counts 15 and 16 are both possession of a firearm by convicted felon counts. Do you understand that you're charged with all of those offenses in this indictment?
Yes, sir.
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And have you had enough time to speak with your attorney, Ms. Woods?
Yes, I do.
And have you had enough time to talk to her about all the facts and circumstances and your options as it relates to the charges that I just spoke about?
Yes, sir.
And are you satisfied with the services that Ms. Wood and her team has provided?
Yes, sir.
And do you need any additional time at this time to ask Ms. Woods any questions you may have in regards to the plea that we're taking today? Are you okay?
Can I answer a question?
You can ask her as many questions as you like.
If you're going to ask her something, why don't you turn away from the microphone so we don't hear it?
At the end, okay? Do
Yes.
you have any other questions?
No, ma'am.
Okay,
Are we good?
we're good.
Okay.
And Ms. Wood, do you waive formal reading of the indictment?
We do.
And do you also, Ms. Wood, waive any and all defects in the indictment, including any with respects to the spelling of your client's name?
So waived.
And has your attorney, Mr. Davis, advised you of the minimum and maximum sentence for each charge you'd be pleading guilty to?
Question means that you and I talk about what you'd be facing if we went to trial. So the most you could get if we lost the trial. Do you understand what that would be?
Yeah.
Okay, so tell him yes.
Yes, sir.
Okay, so I'm gonna go over what the minimum and maximum are for each one of the offenses in the indictment, okay?
Can you hold on 1 second? I'm printing out that we don't have all the charges on the calendar. I'm just printing out the cover page.
Okay.
And I can follow along too. Mr. Davis, where'd you go to high school?
Washington.
Here in the Atlanta area?
Yes, sir. Yes.
It's a slow printer. Why don't you just get started? I'll keep track.
And so, Mr. Davis, as it relates to count 1, murder, do you understand that the minimum sentence for murder is life, the maximum being life without the possibility of parole?
Yes, sir.
You understand that for counts 2, 3, and 4, which are all felony murder counts, the minimum, again, is life, and the maximum for those counts is also life without the possibility of parole. Do you understand that?
Yes, sir.
Do you understand that as it relates to count 5, kidnapping with bodily injury, the minimum for that offense is life, maximum is, according to the statute, it's death, but obviously that's not on the table here.
Yes, sir.
Okay. And do you understand that for count 6, false imprisonment, the minimum is 1 year, the maximum is 10 years?
Yes, sir.
And then as it relates to count 8, aggravated assault, excuse me, count 7, aggravated assault, the minimum is 1 year, the maximum is 20 years.
Yes, sir.
And then for count 8, aggravated sodomy, do you understand that the minimum for that count is 25 years? The maximum is life, and whatever sentence you receive is to be followed by life on probation. You understand that?
Yes, sir.
Okay. And for count 9, possession of a knife during the commission of a felony, do you understand that the sentence for that must be 5 years and it must run consecutive, but it can be suspended, probated, or served in prison? Do you understand that? Just
Yes.
okay. And for count 10, rape, do you understand that the minimum for that count is, again, it's 25 years, the maximum is life. And whatever sentence you receive for that count, it must be followed by life on probation. Do you understand that?
Yes, sir.
Okay. And then for counts 11 and 12, those are aggravated assault counts. The minimum is 1 year, the maximum is 20 years. Do you understand that?
Yes, sir.
And then for count 14, I skipped count 13, I apologize, false imprisonment. The minimum again for that count is 1 year, the maximum is 10 years.
Yes, sir.
And then for counts 14, is possession of a firearm during the commission of a felony. Again, that must be a 5-year sentence and it must run consecutive, but it can be suspended, probated, or served in prison. Do you understand that?
Yes, sir.
All right. And then for the last 2 counts, which are both possession of a firearm by a convicted felon, You understand for those counts, the minimum is 1 year, the maximum is 10 years.
Yes.
Okay, and do you have any questions about any of the minimum or maximum sentences that I just went over for all the counts in which you're indicted with, sir?
No, sir.
Okay. And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel, Ms. Wood, will make a joint recommendation to the court? But do you understand that the court does not have to follow that recommendation necessarily, and that he can sentence you as he sees fit, and then run those sentences for each count that he chooses to sentence you differently? He can do that one after another or consecutively. Does that make sense?
Yes, sir.
And do you understand, sir, that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts, Mr. Davis? Do you understand that?
Yes, sir.
You also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your counsel, Ms. Wood, or anybody else.
Yes, sir.
Okay. You also understand that you waive any and all defenses by entering a plea of guilty here today.
Yes.
Okay. And you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right of the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Mr. Davis, do you understand that by pleading guilty here today, you're giving up or waiving all of those rights I just listed and went through?
Yes, sir.
Okay. And Mr. Davis, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision, Mr. Davis, to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
And Mr. Davis, how do you plead to count one in indictment number 24 SC 006-492-01, murder?
How do I plead?
How do you plead?
Guilty.
And sir, how do you plead to counts 2, 3, and 4, which are all felony murder counts in that same indictment?
Guilty.
Mr. Davis, how do you plead to count 5, kidnapping with bodily injury?
Guilty.
And how do you plead for count 6, false imprisonment?
Guilty.
And as it relates to count 7, aggravated assault, how do you plead, sir?
Guilty.
And for count 8, aggravated sodomy, how do you plead?
Guilty.
And as it relates to count 9, which is possession of a knife during the commission of a felony, how do you plead, Mr. Davis?
Guilty.
And then as it relates to count 10, rape, how do you plead, Mr. Davis?
Guilty.
A question about
Yes.
that. What's the case with Sabrina? The second case. Judge, one moment, please.
Sure.
Do you remember so the state re-indicted this to combine? So counts 1 through 9, right? We talked about that's the first case. 10 through 16 is the second case that we kept calling the unindicted case for a long time, and now it's part of this case. This is the May case. That's the July case.
Guilty.
And count 11 and 12, which are both aggravated assault counts, sir.
Guilty, sir.
And then as it relates to count 13, which is false imprisonment, how do you plead, Mr. Davis?
Guilty.
And count 14, which is possession of a firearm during the commission of a felony, how do you plead, Mr. Davis?
Guilty.
And then the last two counts, counts 15 and 16 are both counts that are possession of a firearm by a convicted felon. How do you plead, sir?
Guilty, sir.
And Mr. Davis, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea? Do you understand that?
Yes, sir.
Okay. And did you have an opportunity or do you need additional time to talk to Ms. Wood anything about what a habeas corpus petition entails? Are you good with that?
Remember we talked about this in the back extensively.
Yes, yes,
Are you good with that?
yes,
Okay. Say yes to the.
yes, sir.
Okay. Thank you, sir. Your Honor, had the state proceeded to trial, the state would have shown during that trial beyond a reasonable doubt that, and I'm gonna talk about events. The first one that we initially indicted occurred on July 4th of 2024, but the counts 10 through 16 involve an offense that occurred a month earlier in May of 2024, Your Honor.
Okay.
So
So you're going to talk about the May situation first or the July?
I'm going to speak about July 1st.
Okay.
So as it relates to the counts 1 through 9 of the indictment involve an incident that occurred on July 4th of 2024, approximately at 5:55 a.m. in the area of 2179 Martin Luther King Drive and the surrounding street area. That address is actually an abandoned house in that area. But what occurred during that time, and what you can see and is captured on video surveillance for an apartment complex, as well as areas, the camera had an area where FUSIS and VIC cameras can capture the surrounding area as well. You can see the defendant, Demetrius Davis, and the victim in this case, Miss Annette Santos, kind of walking along the sidewalk and then kind of crossing the street. As they're crossing the street, you can see the defendant kind of grab her arm several times and her pull away. He continued to do that. And they were talking kind of back and forth where their heads were both turning towards each other. At one point, Miss Santos, in an attempt to get Mr. Davis off of her arm, swings her purse or her bag at Mr. Davis. When she does that, her purse falls into the middle of the street. What you can see on the video surveillance cameras is that Miss Santos then attempts to kind of run and get away from Mr. Davis, but Mr. Davis continues to chase her and follow her. As he is chasing her, she falls in the middle of the street, and as she falls and is down, you can see the defendant on multiple times take a knife and stab Miss Santos along her body and her torso. At that point, the defendant, after he stabbed her, kind of walks away, walks towards the left side of the street, towards the sidewalk, where Miss Santos is there laying in the street. You can see her get up and struggle to get up, attempt to grab her bag. The defendant then comes back and again grabs her. You can see Miss Santos struggle to attempt to try to get away, but she again, because of the stab wounds, falls into the middle of the street. You then can see on the video surveillance camera the defendant drag Miss Santos across the street into the sidewalk where they began, where they could see, where you could begin to see them on the video surveillance camera before the stabbing occurred. He then drags her from the sidewalk and off the camera towards the abandoned house where Miss Santos is eventually found later that mid-afternoon. The defendant can be seen on the video.
Is there a blood trail from the, I don't know.
There is.
From the middle of the street to the sidewalk to the house where she's found?
There is a blood trail where you can see in the middle of the street and the sidewalk. It's the blood trail kind of tails off, or you can't see it as he continues to drag her because there's grass and there's wooded area and things of that nature. But there is blood found where she is eventually found behind the house at 2179 Martin Luther King Drive. You can see on the video surveillance camera the defendant emerge back from where he came, where he dragged Ms. Santos's body about approximately 45 minutes after he initially dragged her behind the house. What you can see as he continues to walk is his actual face on a T-Mobile store video surveillance camera that is right down the street on Martin Luther King Drive, as well as the kind of clothing that he had on, which match what you can see on the initial Fusus, Vic, and the apartment complex that's near the location. You could see the general description of his clothes and pants and things of that nature. Ms. Santos is later found by a citizen who's walking by or walking through the backyard to get to the street. Obviously, the police arrive, and the detectives with the Atlanta Homicide Department began their investigation. They got several tips as it relates to this defendant being the perpetrator of the crime, but all of the tips were anonymous. They were through Crime Stoppers and things of that nature. Mr. Davis was later
based on some kind of photo that's shared, or
a bolo was sent out. They did a press conference as well as a bolo was sent out through the city.
Okay. An anonymous caller say the person in that picture is Mr. Davis, or whatever they share.
That's correct.
Okay.
And Mr. Davis, being a person of interest at this point, later, July 7th, is arrested on an unrelated charge. I believe it's a public intoxication, and he had a warrant, an outstanding probation warrant. He is taken back to APD homicide headquarters, where he's Mirandized, and Detective Fall speaks with him. He denies any involvement in what occurred to Ms. Santos on July 4th. But on that date, his buccal swab is taken for his DNA, and that is sent to the GBI along with the rape kit that was done on Ms. Santos by the medical examiner. Back later in November, there's a match as it relates to the DNA of this defendant being found inside of Ms. Santos's anal area or cavity. And based upon that, warrants are taken out by Detective Fall for the crimes alleged in counts 1 through 9. The defendant is later arrested. I believe it's October 6th. He's seen in the area of Zone 1 after a 911 call was actually made by a female friend that was with this defendant that night. She called.
Meaning the night of the murder or the night he was arrested?
The night he was arrested.
Okay.
On October 6th. As a result of that 911 call, in which the female caller that was with the defendant said she's with the individual. He went by the, nickname of Meatball, that she's with Meatball at a specific location. It was a Chevron in Zone 1. Zone 1 officers immediately respond, and that's where he is eventually arrested and taken into custody. A month prior, on May 3rd, make sure I have my May dates right, so I apologize.
You say a month prior, meaning a couple months before the July 4th situation?
Yes.
Okay.
A month prior to the July 4th situation, so it was May 3rd, 2024. Miss Sabrina Holland, who was the significant other of somebody who, Mr. Houston, who lived with Mr. Davis at the time in May. She was coming to meet Mr. Houston, her boyfriend.
She was the significant other of Mr. Houston, or a friend of Mr. Houston?
She was the significant other of Mr. Houston.
Who's roommates with Mr. Davis?
Yes, Your Honor.
Okay.
And they lived at 149 Dahlia Avenue, which is Dahlia, here in Atlanta, Georgia, Fulton County. She had come to that house because her and Mr. Houston had planned a a dinner date that evening. When she arrived, Mr. Houston was not there. And so she went down the street to 109 Dahlia Avenue, where Mr. Houston's mother stayed, knocked on the door and was able to gain entry into his mother's home, and waited there because his mom said that she had spoken to him earlier, he being Mr. Houston, and that he would be there shortly. During that time, while she is waiting at Mr. Houston's mom's house, the defendant arrives at Miss Houston's home, gives Miss Houston I can't remember, it was a monitor, some sort of equipment that she needed. And during that time, Mr. Davis and Miss Holland had an exchange. Mr. Davis requested if Miss Holland would take him to their house at 149 Dahlia Street, and she agreed to drive him down to their house that he shared with Mr. Houston. Once they arrived, she waited in Mr. Houston's bedroom for him to get home so they could go on the plans that they had already prearranged. During the time that they were waiting, the defendant came into Mr. Houston's bedroom where Miss Holland was waiting. And the first time he came in with a long gun, a rifle or shotgun of some sort, pointed it at Miss Holland and told her, you know what time it is, take your pants off, basically undress. And at that point, began to threaten her if she didn't comply. He then, because she wasn't moving fast enough, began to take the pants of Miss Holland off. He successfully was able to take her pants off and attempted to penetrate her vagina. While doing that, there was a struggle, and Miss Holland was able to get away in the sense that was able to get out of the grips of this defendant. After she did that, she attempted to try to get her pants. He got out of the bedroom first, went to his room, got another gun, a handgun at this point, and pointed it back at her head, threatened to kill her if she didn't comply, and began to penetrate her vagina at that point. He did successfully penetrate Miss Holland, and as Miss Holland told police later that evening, he ejaculated inside of her vagina, and after doing so, told her that if she told anyone what occurred, that he would kill her. At that point, she immediately left the residence, 149 Dahlia, and immediately went back down to 109 where Mr. Houston's mother lived, and immediately called 911 and made the rape outcry. She was immediately taken to Grady Hospital, where a sexual assault exam and kit were done, and it was later sent to the GBI. The swabs from the sexual assault kit were then compared to this defendant's buccal swab, and there was a match as it relates to the DNA that was found inside of Miss Holland's vaginal cavity, Your Honor. She was able to obviously identify him after being shown a six-pack photo lineup, and that would have been the facts as it relates to that incident.
How was Mr. Davis not? So there are 2 months between what happened to Ms. Holland and what happened to Ms. Santos.
Yes.
Did Mr. Davis get arrested for the Holland situation and bond out, or she said, "This is who did this to me." Could they not find him? So he was a lowercase f fugitive. You didn't necessarily know they were searching for him?
The investigation, so at the initial part of the investigation, after Ms. Holland made her initial outcry, she only knew his first name. At that point, Mr. Houston, his roommate, was not overly cooperative as it relates to identifying the last name and other identifying, characteristics for this defendant, or identifying information like date of birth and things of that nature.
They didn't have enough information to say this is who we're talking about.
That's correct.
How did they get the photo to show her a six-pack lineup?
So the photo was given to, the photo that was used within that six-pack photo lineup was in conjunction with, after Detective Fall was able to make his identification.
That all happened after the Santos situation.
Right.
The things you were describing about picked him out, obviously the DNA hit. So the investigators handling the case involving Ms. Holland really were able to connect dots after after Ms. Santos's situation.
That's
Okay.
correct, Your Honor.
All right.
The recommendation from the negotiated recommendation as relates to the counts in indictment number 24 SC 006-492-01. Count 1, murder, would be life. Counts 2, 3, and 4, which are all the felony murder counts, would vacate by operation of law. Count 5, which is the kidnapping with bodily injury, would be a life sentence, but it would run concurrent with count 1. Count 6, false imprisonment, would merge with count 5, kidnapping with bodily injury. Count 7, the aggravated assault with a deadly weapon, would merge with count 1, murder. Count 8, aggravated sodomy, that would be a life sentence, but it would run concurrent with count 1. And by statute, it has to be followed by life on probation if he was ever to be released on parole. And then count 9, possession of a knife during the commission of a felony, would be 5 years consecutive but suspended.
Okay.
And then as it relates to count 10, rape, the recommendation is 25 years to serve, followed by life on probation, consecutive to count 1, murder. Counts 11 and 12 would both be 20 years to serve. That would be concurrent with count 10. Typically, one would merge with the other, but he used 2 firearms during the incident. Count 13, false imprisonment, is 10 years to serve, but concurrent with count 10. Count 14, possession of a firearm during the commission of a felony, would be 5 years consecutive to count 10, but suspended. And then counts 15 and 16, possession of a firearm by a convicted felon. Both of those would be 10 years to serve, but concurrent with count 10, Your Honor.
So it's a total of life plus 25 plus lifetime on probation.
Yes, Your Honor.
It's life plus 25 plus 5 suspended, because I think count 14 would have to run consecutive to count 10.
That's correct, Your Honor.
So life plus 25 plus 5 suspended, but also lifetime on probation.
Yes, Your Honor.
There was a recidivist notice filed. I haven't looked at it. I don't know if it's an A or a C or both, but you're withdrawing that? Okay.
Nothing from the state until Your Honor believes or finds it's appropriate. There are several members of the Ms. Santos's family who are all appearing via Zoom. Her daughter, her son, and I believe her husband is on the Zoom. And then Ms. Holland is here in the courtroom who'd like to make statements for whenever.
Great. And I'll want to hear from each of them. Why don't we just round out the picture you've drawn by hearing from Ms. Jackson. Good afternoon, Ms. Jackson. If you could share with me criminal history information on Mr. Davis, please.
Yes, sir. There are 26 cycles. The last arrest was May the 26th, 2020, with the City of Atlanta Police Department for criminal damage to property in the 2nd degree. There are prior felony convictions, one in 2020 for criminal damage to property in the 2nd degree, and there was one in 2008 for burglary and possession of marijuana with the intent to distribute, and possession of cocaine with the intent to distribute. And there are misdemeanor sentences and convictions. He received a nolo contendere sentence in 2019 for theft by shoplifting. He received a nolo contendere sentence in 2015 for possession of marijuana less than an ounce. There was a conviction in 2009 for criminal trespassing. This one in 2007 for obstruction of an officer. One in 2006 for disorderly conduct. Nothing in addition, Your Honor.
Thank you, ma'am. Mr. Body, I'm happy to hear from folks in whatever sequence you or the victim advocate want them to occur.
But yeah, probably easiest to start with people on Zoom.
Okay.
Any of, I know Ebony Santos is on with the daughter, and then everyone else can follow her.
All right. So Ms. Santos, Ebony Santos, if you could turn your camera on, please. And then your microphone. And when you're ready, if you could introduce yourself, tell me, please, how you are connected to Ms. Santos, and then anything you want to share with me about how you're doing, how your family is doing, and what you think ought to happen. I'm here to listen.
Yeah, thank you, Your Honor. Am I audible? Okay.
Yes.
Okay. My name is Ebony Santos. I am Annette's youngest child, her only daughter. My family and I are getting by as best as we can. I would be there in court today, but I'm in New York on business, and we got a 24-hour notice that this was happening. My mother raised 4 children with my father. We all have advanced college degrees, advanced careers. We have no criminal records. And yet, none of that exempts us from being in court today in this manner. The amount of pain that has been inflicted on myself and my family by not only losing our mother, but in the most heinous and violent ways has changed us forever. Our mother was loved, she was wanted, and she was needed. As her only daughter, there is so much in my life that I will now have to do without my mother. I get married, and when I have my first child, when I need to share great news about whatever's happening in life, or just vent. No matter how old I get, I will always need my mother. And the defendant has robbed me of having my mother in my life for the rest of my years. I am the same age as the defendant, and I have to live every one of my days of my life without my mom. I think that the defendant should live every day of his life without seeing the outside of a jail cell. And I still think, honestly, that is too lenient. My mom is not just another victim. She had a family. She did not deserve to be attacked, raped, and then left like nobody, lifeless and alone. And I can't imagine the fear and pain my mother went through in the last moments of her life. To the sick individual that did this, personally, I don't think that someone who's capable of doing what this person has done to my mother, and to hear about the woman that had to suffer on the hands of this man 2 months before my mom, people like that don't deserve to live. But I never want this person to see the day of life. A life with the possibility of parole. I don't think that this person deserves to be put out in the streets. I think they're a danger to everybody. And I think that is proven by the fact that they were able to do this and not only escalate within the span of 2 months. I hope that the defender suffers immensely every day for the rest of his life. And I hope you are violated in the same ways you violated my mother and the other woman, and possibly other women. I want you to spend every day for the rest of your life behind bars until the day you die. And may that day come sooner than later. In Your Honor, I ask that the court ensures that the defendant is never able to get out. That's my piece.
All right. Thank you, Ms. Santos. I appreciate you joining us. I want to comment real briefly on the short notice. We're taking this plea today sort of on the eve of trial. Trial was supposed to start on Monday because this opportunity to prevent Ms. Holland from having to testify at trial, and from you, Ms. Santos, and other family members from having to come down here and sit through a recreation of what your mother went through for 14 strangers, because that opportunity presented itself. And I directed the parties to come here post haste once Ms. Wood said that Mr. Davis was prepared to enter a plea. So I apologize that you are there and not here. Your comments to me are no less powerful because they're over a screen instead of you being here in court. And it might be safer for everyone that you are there and not physically present with Mr. Davis right now. But I'm sorry insofar as you wish to be here in person. But I have learned from many years on the bench to strike when there's an opportunity to take a plea, which brings not closure to your family. I don't mean to pretend that at all, but it is finality in the sense that a plea is the end of the proceedings. We don't have the trial and then an appeal and a motion for a new trial. The door slams shut. And given the facts of this case and what your family has gone through and what Ms. Holland has gone through, that's how it needs to end. So that we are not again coming back and picking at the wound and the gap in your life. So again, I'm sorry that you're not here. No one was trying to rush anything other than here was an opportunity to get the finality of a plea rather than a trial and all that that involves, and then the years of appeals that follow. So just to explain that process. We have a couple other, I believe, members of the Santos family. You may feel like Ebony Santos has spoken what needs to be spoken, but I don't mean to preclude anyone else. So if there are other family members, I'd ask you to turn your camera on so that I know you want to speak. And if I don't see any cameras turn on, then I'll know it's time to turn to Ms. Holland to see if she wants to be heard. Rashad Santos, you'd like to speak?
Good afternoon, Your Honor.
Good afternoon. If you could spell your name for the record, and it may be exactly as on the screen, in which case we're good to go, and then let me know how you are connected to Ms. Santos.
It is spelled exactly as it is on the screen there. I'm my mom's oldest son, Ebony's oldest brother. There's two in between us that weren't able to make it today due to their work obligations. As Ebony already stated, we would have definitely planned to be there today. I actually tried to find a flight to get down here today, but I couldn't with work and everything else. But nonetheless, my sister summarized everything that I possibly was going to say. The only thing I will say is beyond just children, grandchildren. My mom had maybe 14, I think 13 grandchildren, four which are currently in their, pursuing their college careers, college degrees, one about to join the military, and the rest are scattered between high school, middle school, elementary school, and soon to be going to elementary school. As I sit here today and I watch and listen to everything that relive those things again, and I think about the safety of our community as I'm preparing to do hurricane weather forecasting for us to save and make sure everybody in the nation's safe. I couldn't echo the sentiments to my sister any further in telling you that to even have somebody of this magnitude walking around the streets, this evil does not deserve to be in the streets. While we don't question God and his will, there's no place for evil in our society, and evil should not be on the streets. So I'll save a lot of what I wrote because my sister captured it all. But this evil does not need to be in the streets, and that should not be the possibility to be on the streets again. It cause more harm and havoc to those other people out there and their loved ones. These are the two that got caught, but I'm pretty sure this is not the first and second attempt that this has happened. So I'll leave it at that, Your Honor. I appreciate the time. And my sister spoke eloquently on behalf of the family, and I have nothing else to add. So.
Well, Mr. Santos, I appreciate you dialing in as well. And I'll just repeat the apology that the timing was such that you couldn't be here in person, but your words were heard just as clearly and as effectively as your sister. So thank you for contributing. All right. I think that is it. Ms. Santos, do you know, I think Mr. Abate said that your father is on as well. Does he want to be heard, or are you and your brother the spokespeople for the family?
Yeah, I think, Dad, you're going to be okay. If you want to say something, now is your okay.
All right. Oh. Mr. Santos, I can't see you. Do you have a camera?
Together. I think he's got a bad connection there, Your Honor.
Okay. Mr. Santos, we're not able to hear you. Do you have another way of connecting? You could go audio only if that might make the sound come through, but we're not able to make out what you're saying. Oh, now we can see you. Mr. Santos, I'm going to turn to Ms. Holland to see if she wants to add something. We can see you now. There's not any sound coming through, but if you want to go offline real briefly to connect with either of your children to see if there's a way I can hear from you, I'm happy to do that. I can also, if your children ask for that, say we need to just get you on the telephone. I got a telephone right here. If you want to dial up, we can put you on speakerphone. But you also may right now think that your kids have spoken on your behalf.
Your Honor, let's continue and we'll get with my dad in the background and let you know.
Please do. Thank you.
Mm-hmm.
All right. Ms. Holland, you do not have to say anything at all, but if you want to, I do want to hear from you. I'm going to ask Mr. Davis and Ms. Wood to go back to the defense table while Ms. Holland comes on up to either, why don't you come to the prosecution? You can take a seat in that middle seat, please.
Thank you.
Ms. Holland.
Yes, sir.
I very much would like to hear from you, as comfortable as you are talking. If there's something you prepared in writing, you could have the advocate read it. Whatever is easiest for you. My only request is that you talk to me. You may have words for Mr. Davis, but you and I are the ones having the conversation, okay?
Yes, sir.
All right, you let me know how you want to do this.
I will talk to you.
Great. I will listen to you.
Yes, sir. I want to start by saying, again, I tell you, it is easier for a camel to go through the eye of a needle than for a man to enter heaven. Who can be saved? Jesus said, with a man, this is impossible, but with God, all things are possible. I want to say good afternoon, Your Honor. I would first like to address the court in fashion of being very thankful to Atlanta Police Department, Detective Williams James and her colleagues, to Mrs. Carla Martinez and her colleagues, to the USDAs of the state of Georgia, and all other persons that made this process go smooth and timely. And of course to you, Your Honor. When I think back to May 3rd of 2024, my heart rate increases, my mouth gets dry, my blood pressure fluctuates, and I begin to succumb to AFib. I think of myself and how this was my fault and could have been avoided had I stayed in my suburban life and not tried to rescue and truly love people. Edric Houston. I lied to my daughter about where I was and what truly happened to me because I was flabbergasted with myself, disgusted, and self-loathing at this heinous thing that truly happened to me in my senior years of life. As a young girl, through young adulthood, I have been hurt in many ways. I buried tragedies deep inside myself because I never thought anyone would believe or advocate for me. So when I found that this crime had been solved for me, I felt for the very first time a true sense of relief within myself. I felt really human and important to others. Other victims of Mr. Davis are not here,
but they are. Nor could they be able to celebrate a victory where someone in their family was hurt. However, as sure as I stand here before this court, my heart is very heavy for them all. I feel victorious within this instant. However, another mother, sister, cousin, auntie, grandmother, and friend lost her life to this sick individual, and for that my heart aches for her. I bless her soul that she has found comfort in the Savior's arms. I bless her remaining family for strength and perseverance to go on and live. This was a hateful, hurtful, and shame, and should go down in the annals of justice as follows. Demetrius Davis, you will never see the break of dawn. You will never know again to enjoy freedom. You will cry many, many days because now you are at the mercy of the judicial system. Fellow inmates and Satan himself, visions will haunt you. Your heart will ache. You will not rest well. Your food will be cold. You will think to yourself of what you could have done or should have done. Nevertheless, God is. Therefore, there was and is no escape for you. You chose this path, Mr. Davis. You could have been successful and thriving, but now you will never belong to yourself. However, let me take the time to tell you, with all others and physical things that you have done, there is no other way but to God. Learn of him, that he may bring you comfort, that your soul may be saved, because your ass belongs to the state of Georgia. That's all I have to say.
Ms. Holland, I appreciate you sharing that, and I followed closely, and it sounds like you have evolved away from blaming yourself. You have no responsibility for what happened to you. And one of your first phrases was it was your fault. But I think you've let go of that perspective and understand.
I'm dealing with that because I feel like had I not been there, I would not have been in that trouble. But at the expense of another sister losing, that's how we found out everything. And I say thank you to the judicial system because it was quick and swift. A whole year is nothing compared to other cold cases. So, Judge McPhinney, I hope I'm saying that correct.
It's fine.
I bless your decision, and I trust your decision here today. And based upon what we've heard from the facts given in front of us, that you will make the best choice possible for this particular case. And I trust in you.
Well, thank you. I hope that you continue to move away from the blame. You were where you were, and what happened to you should happen to no one. You did nothing to deserve it. You did nothing to have that befall you. And so I hope you continue on your path towards understanding that while there's no good explanation for what happened to you, none of it was your fault.
Yes, sir.
Okay?
Yes, sir.
All right. Thank you for being here.
Yes, sir.
Ms. Santos, do you have a technical update?
Yes, I do. So I think let's dial in. We can get Dad, if we can get a number for him to just dial in and speak.
Yep. Let me see what I can do here. I have this phone here. You ready? It's 404. You know what I'm going to do? I'm going to put it in the chat to you rather than just put it out here because no one needs this phone randomly being called during certain times. So let me send it to you and you can get it to your dad. All right. You got it?
I do. Thank you.
All right. You'll share that with your father. he can call, I'm gonna put it on speakerphone, it'll come over my microphone so that Ms. Rivers, our court reporter, can take it down. We'll wrap up with that from the state side, and then I'll have Ms. Wood and Mr. Davis come back to the podium, and we'll hear from the defense.
All right, thank you. I've sent the number. Call should be coming in now.
Got it. Mr. Santos, can you hear me?
You hear from the defense.
Mr. Santos, are you there?
Yes, I'm here.
All right.
Okay, then. How you doing, Jan?
Okay.
Okay. Yes, my children put it beautiful, personally, and I don't know too much more I can say, but I would like to say that, Angel, as we call her, left me with a beautiful legacy. Though she's gone, she'll always be with me. And as I sat through the proceedings, I was just so grateful that I didn't get a chance to be one-on-one with Mr. Davis. I'm so grateful because things would have been a lot different. That'd have been me on trial, guarantee you. But all that being said, that was like initial anger, if that makes sense. The initial anger, but as the year went on, and I was able to deal with the finality that she's gone. I'm never going to see her again. And in my mind, 10,000 times, I thought of what I could have did different. And I asked myself, there was nothing I could have did different. And just to see someone, just so much bigger than her, just stab and just take a life. And I just know deep down inside where I feel that ain't the first time he did it. Not the second time. You just don't do something like that. I mean, that's not normal. That is not normal at all. And like my son said, something that evil should not be walking the street. Ever. Ever. And like I said earlier, my kids put it eloquently. I mean, that legacy, she left me with a beautiful legacy. And I'm going on trying to play, grandfather, father. But a part of me is always missing. Got a void. He created a void in my heart, in my life. And I have to go on the rest of my days with that void. So, Your Honor, I know it's up to the court, and I just hope that he gets what he deserves. No more, no less. Thank you.
Thank you, Mr. Santos. I appreciate you working through our technical difficulties.
No problem.
Ms. Wood, do you want to stay where you are, or is it okay coming back to the podium?
We'll come back to the podium, Judge.
All right, let's do that.
This way.
So we've heard a lot.
Yes, Judge. Would you like me to go ahead and get
I'm ready.
started?
Yes,
Okay.
ma'am.
I would just like to remind the court that several months ago, I think it was at the beginning of the summer, for our final plea hearing, I anticipated that it would just be the final plea hearing. So I had a colleague stand in for me. And then Mr. Davis came out from the back and indicated to the court that he was ready to accept responsibility. And I'm telling the court that today to let everyone know that Mr. Davis wanted to accept responsibility back then. And the reason we've had this extra delay is because I wanted to make sure that I left no stone unturned and to continue negotiating with Mr. Abadi. So he has been standing here. He's been eager to enter a plea and accept responsibility and spare everyone the what would happen at a trial, Judge. And so I just want to get out front and say that our office actually hired Dr. Norman in May of this year. He worked extensively with Mr. Davis. Mr. Davis does suffer from multiple diagnoses. He is diagnosed schizophrenic. He also suffers from psychotic disorder, anxiety disorder as well.
And those, I think you shared with me before, and it's important to take into consideration, but you are not suggesting at this point that Mr. Davis is in any way not capable of understanding what we're doing today.
That's correct, Judge.
Okay.
Dr. Norman deemed him both competent to stand trial and also criminally responsible at the time of the incidents. So given that he has these diagnoses, I also, just from a couple of things I saw in discovery, I think there might have been some substance usage on Mr. Davis's part during these incidents as well. Obviously, that does not excuse anything, but I'm just adding that for context. Judge, I am here begging that you accept our negotiated resolution for this case. Mr. Abadi has been very thoughtful in his recommendation. Mr. Davis has family here. He has his mother and his uncle. He's 38 years old. He was born and raised here in Atlanta. At some point in his life, he was able to be gainfully employed. He worked for a trucking company. He loaded 18-wheelers, and he's also done landscaping work. Judge, he is accepting responsibility. I don't know if you noticed, he was feeling remorseful and a little overwhelmed by emotion at the table. So he is deeply sorry for both of these incidents, Judge. And I don't know if his family would like to speak, but I would let them address the court if they do wish to do that, Judge.
Okay. Do either of you want to be heard, or you're good having Ms. Wood speak for you? You'd like to be heard? Okay. If you can come up and you can sit at the middle seat of the desk where Ms. Wood and Mr. Davis had been sitting. If you could introduce yourself, please, and let me know how you are related to Mr. Davis.
My name is Nora Davis.
I'm sorry, I need you to speak up.
My name is Nora Davis.
All right, Ms. Davis.
I'm the mother of Demetrius Davis.
And what do you want to share?
I wanted to share that Demetrius, when he was young, this is what we did for a living. My mama owned a personal care home. She was a nurse at Grady Hospital. She retired. Demetrius used to help the senior citizen tie their shoes. My mama taught us how to turn them and bathe them and sit them on the house. Demetrius not, oh God. She taught us how to take care of senior citizens. I've been taking care of senior citizens ever since I was 16. I'm 58 years old now. I'm still taking care of senior citizens. I do sit-ins. But Demetrius has a heart. Trust and believe, he has a heart. I don't know what happened. I don't know what went wrong, but he has a heart and he has a caring heart. My daughter had 7 kids and he took care of them. We got college and graduates too. And it hurt them very much because they represent, Demetrius represent as their uncle. I tell Demetrius, and he's very close to church. He was raised in the church, y'all. My mama carried him to church every Sunday. Every other Sunday he might miss. I am deeply sorry for anything and everything. I goes out to everybody. I take care of people every day. Demetrius know this. This break my heart go out to the family too. If he Demetrius know that's my baby. And I don't want to tell y'all the family or the chief, but I want you to know that this child was a loving child. And not only that, he cared for other people. I don't know what went wrong, but it's in our blood to care for folks. When they told me Demetrius did this, I couldn't even believe. They said this happened more than one time. That's not true. But my heart go out for all of y'all. I'm so sorry.
And me too, you
All right, hey, Mr. Davis, I'll hear from you in a second. Promise.
I'm so sorry for each and every, even the ones that's in the courthouse. I'm sorry y'all had to hear this and go through this. But Demetrius is not no evil person. I tried Social Security over and over. If y'all would look back, how many times I tried, I had got sick. And I told Demetrius, I sat down and talked to him. I told him, I said, babe, I don't got sick now. I got to have somebody to take care of you. Because I wanted him to put him in a group home so he could continue taking his meds. And the people could take care of him. He done went to the hospital so many times, y'all. If you ever look at his medical records, he done been to the hospital so many times, over 50 times, not 100, asking for help. We went and took him down on 10th Street. And they let you sit in the chair for hours and hours. I really can't say nothing else.
Well, Ms. Davis, it was important for you to speak. It's important that you're here.
Yes, sir.
It helps everyone see that your son is loved and that he has a family. And I know it is important to him that he's not here alone.
Yes, yes.
So I appreciate you sharing what you shared. Thank you.
Thank you so much. And God bless all of you. Thank you, Jesus.
Mr. Davis, I interrupted you only because I was saving till the end for you to share anything you want to. You don't have to say anything at all, but you have a right to be heard if there's anything you want to say. Your words may go to other people, but I want you to talk to me or the screen. Don't turn around and address other people. Just tell me if there's something you want to say, but you're not obligated to say anything at all.
So I just wanted to say, I am sorry for everything, and that's all, sir. Just my mom was right. I was a good person, and still is, but that's all, sir. That's all, Mr. McBurney.
All right. Thank you, Mr. Davis. Ms. Wood, anything else?
No, Your Honor.
All right. Mr. Abate, anything else from the state? Mr. Davis, I meant it. I meant all the things I've been saying, but I meant it when I said to your mother that it was important that she was here because I think she illustrates that people have different aspects. And I have no doubt that when you were a kid, you were a good kid, and around your mom, you have shown that you have a heart. But I'm also confronted with some of the most alarming and disturbing conduct that I've ever seen. Ms. Santos described it as hideous and violent. Rashad Santos described it as evil, and that's not me saying you're evil. I'm not taking sides and putting labels on, but the things that happened were hideous and violent, and they were evil, and they happened twice. It's got to be hard for people to process how it could happen more than once, and why the system didn't kick in to try to get you to where you are now, so that there wasn't a second or third or a fourth or a fifth victim. Blessedly, Ms. Holland survived. Ms. Santos didn't. And you saw what I saw, which is some very hurt and very angry people. And they don't forgive you, and they don't have to forgive you, because what happened was unforgivable. That doesn't mean you don't have a heart, but it means that the things that happened were awful and cruel, and they have left for Mr. Santos and his family a situation where part of them is always missing. Those were his words. And you can't give that back, however much you might want to. My job now is to figure out what best protects everyone else that you haven't been able to interact with in this way. And I take that role pretty seriously. So first, I find there's a factual basis for your plea. And all that means is that if the jury heard what I heard today, the jury could find you guilty. I don't know that they would, but with the DNA, with the video footage, with Ms. Holland as an eyewitness survivor, I bet the jury would find you guilty. But I don't need to make that decision. I'm just telling you that it sounds like the state has enough evidence in this case that your plea is supported by that. I also find that your plea is voluntary. All that means is that you're entering this plea after having had a chance to speak with your lawyer and maybe your family of your own free will. No one's forcing you to do that. Do you agree with me?
Yes, sir.
I also find that your plea is knowing. That means you've understood the things we talked about. And if you didn't, you asked for a break and you and Ms. Wood talked about it. And so she explained to you in words that you understood the things we've been discussing. Do you agree that so far you followed what we've been talking about?
Yes, I do, sir.
Okay. At this point, do you have any questions for me or for Ms. Wood about anything?
I just want to say I'm not the same person, but I'm staying prayed up, and everyone stay blessed. And I know not. I gotta come and see it's not if or someone was to, when I would not go out and do nothing wrong.
Okay. And it may well be, Mr. Davis, that when you're getting the right care and you're taking the right medicine, that we wouldn't see this side of you. That's possible.
Yes,
but it may be when you aren't doing that, because you're an adult, your mom can't make you do things you don't want to do. And the way you're trying to stop the voices is by, and I don't know if it's cocaine or something else, but if you're self-medicating, then you find yourself in this kind of situation. And as Ms. Wood put it, and I agree with her, it doesn't justify any of it. It explains why someone who right now is standing here and is speaking calmly and has people who love him might end up in a situation like that. But I think you can understand that whether it was because you were medicating yourself or weren't doing the certain things, none of that brings back Ms. Santos. None of that returns a sense of peace and serenity to Ms. Holland. And that's where we are. Ms. Wood, do you authorize someone in my office to sign the indictment on your behalf?
Yes.
Mr. Abate, can we sign for you?
Yes.
Mr. Davis, we do electronic signatures now, and so I'm asking your permission to have someone in my office electronically sign the indictment on your behalf, just memorializing the guilty plea that you've decided you want to enter. Is it okay if we electronically sign your name?
Say yes.
Yes.
Okay, we'll do that. Thank you. Mr. Abate, are you going to move to null pros, dismiss the original indictment, the one ending in just the 492. Okay, we'll take care of that. And you said it before, but because I'm about to pronounce sentence, I want to have it close in time or space in the transcript. The state is withdrawing the recidivist notice.
That's correct.
All right. Mr. Davis, I'm going to sentence you on count 1 to life. Counts 2, 3, and 4 vacate by operation of law. You don't get a sentence on those. Those counts go away. Count 5 is a sentence of life. That'll run concurrently or at the same time with your first life sentence. Count 6 merges into count 5. No sentence there. That count goes away. Count 7 merges into count 1. No sentence there. Count 8 is it. I apologize for that interruption. Count 8 is also a life sentence. It will run concurrently with count 1. Count 9 has to be 5 years. It has to run consecutive to count 1. So it is 5 years to serve consecutive to count 1. Those are all the counts that relate to what I'm calling the Ms. Santos case. The next set of counts relate to what happened to Ms. Holland. Your sentence as to count 10 is a sentence of life. It will run consecutive to count 1. Your sentence as to count 11, need to get the indictment back up on the screen. Count 11 is 20 years. Count 12 is 20 years. Those will run concurrently with each other and concurrently with count 10. Count 14 has to be 5 years and it has to run consecutive to count 10. So that'll be 5 years to serve consecutive to count 10. Counts 15 and 16 are both 10 years to serve and that'll run concurrently with count 10. So your sentence is life followed by another life sentence, followed by 5 years to serve. And I think I have to say followed by life on probation. I'm required to say that by law. I don't think you're ever going to be on probation. I don't think that's how this is going to play out. But if for some reason you would be on probation for life and you'd be required to register as a sex offender.
So you said I won't be on probation?
I don't know how it will play out. I don't control how pardons and parole will handle this. And I'm going to give you some hypotheticals, and don't quote me on this. The governor could commute your sentence. I don't think the governor's going to do that, but the governor could say, oh my gosh, Mr. Davis has been a model prisoner. I'm going to commute his sentence after 27 years. I'm making the number up and I'm making that fact up. If your sentence were commuted, then if you'd still be alive, the rest of your life, you're on probation and you'd have to register as a sex offender, which would affect where you can live and what kind of work you could do, et cetera. You also could have the Board of Pardons and Parole decide that they are going to release you on parole. If you're released on parole, that is functionally the same as probation, and you would be required to register as a sex offender, which would affect where you can live and what you can do for a living. Couldn't be a school teacher, can't live near a school, et cetera. Those decisions are beyond my span of control. And I don't want you to leave here thinking the judge said, I'm going to get paroled. The judge said, I'm going to get probation. I don't think that will happen, but if it does happen, just know that it is parole and probation for the rest of your life and that you'd be registered as a sex offender while you're doing that parole or that probation.
So you saying I don't come get parole?
I'm saying I don't know because it's not my decision. There's a different organization called the Board of Pardons and Parole, and they will look at your sentence a ways down the road to say, is this someone who has been doing well in prison, not getting in fights, not making trouble for the warden? They'll look at what you were convicted of, pretty serious stuff, but they will decide whether you're eligible for parole. Because you pled to murder, don't even think about that second case. Because you pled to murder, right now, you're not eligible for parole for 30 years, 30. But that's something you knew going in. If all you had done was plead to the Miss Sanders case to life, you wouldn't be eligible for parole for 30 years. But given your age, you could still be alive 30 years minus however long you've been in jail for now. And you'll be considered for parole. I don't know what they'll do. They don't ask me. I'm not going to be a judge then anyway. But they wouldn't say, hey, McBurney, what do you think about Mr. Davis's situation? So yes, you'll be considered, but it wouldn't be for many, many years. Okay?
Yes, sir.
All right. Mr. Abadi, anything else from the state?
And I may have missed you, I think you may have skipped count 13 that relates to a sentence, and I apologize.
No, you're probably right. Because I couldn't print out the new indictment, I've had to scribble some stuff down. I don't think I did. 13 is 10 years to serve, and it is concurrent with count 10. So I didn't change your sentence at all. It's just something that's running at the same time. The only counts that shouldn't have a sentence are 2 through 4. Those were vacated by operation of law. 6, which merged into 5, and 7, which merged into 1. I intended to pronounce a sentence for all the other counts. Ms. Nelson, any questions about any of that?
No, Judge, you covered it all. Thank you.
Oh, and she sent a note too saying, what about count 13? I missed that. Ms. Wood, anything else on behalf of Mr. Davis?
Mayor, thank you.
I appreciate your work on his behalf. And to the Santoses, again, I apologize you weren't here in person. You were seen, you were heard. And Ms. Holland, best of luck with everything. You may. Thank you. Thank you so much. And Mr. Abadi, thank you on the Darrell Lowe front as well. Will you be there on Monday or Mr. Fawcett? Okay. Okay. Well, we're just waiting to hear whether Mr. Lowe, it'll be in 7E regardless. It's just a question of who will be sitting up at the bench. She and I had, I bet, because it remains her issue and not Mr. Nails or whoever the commissioner is. Take care.
Have you taken an announcement, Mr. Beck? Any chance there?
Yes,
I have.
it doesn't need to be on the record.
Yeah.
No,
I have
okay.
a wait- Well, I guess I have a waiver agreement and all the address change forms. The court also asked me to go through each of the cases and see if there were any charges that he did not receive on the one when he was initially arrested.
Yeah.
I did that, and I also communicated with Ms. Nelson via email.
Perfect.
So we confirmed everything. He does not have a bond on 3 of the counts.
But it's counts that every case he has a bond.
He has a bond on every case.
That makes it so much easier because then we're just amending bonds. Okay.
I don't know if you want me to.
If you told her, I can work with her, meaning Ms. Nelson. If she knows the counts for which there's no bond, then I'll amend the bond. I'll need to add we'll work with you on this. Sometimes the bonding companies say, we can't just amend a bond like that. So let me look at what you shared with her, and then we can via email. And I'll include Ms. Williams on the email, but I'll also include Ms. Davis, because it's going to be Ms. Davis going forward, but Ms. Williams can just be the boots on the ground who was here saying, yes, they talked about that.
I figured as much, but I didn't want to leave just in abundance of caution, just in case.
I'm sorry this plea took so long, keeping you trapped.
Yeah, I mean,
It was what it was.
so, should I leave this with the court?
You can hand it to me, and I'll get, so that's the waiver and the change of address.
That is correct.
Great.
Thank you.
Thank you so much. Yes, ma'am. Appreciate your work on these. Okay, you did a different change of address for each one. Thank you.
Like it's a rush.
Yep,
Have a good day, Judge.
you too. Should we do Mr. Jones now, Ms. Wood?
Yes, Judge. And so I've been emailing back and forth with Miss Davis about Mr. Jones. I realize she's still in trial.
Ms. Davis is in trial?
Yes. Yes.
Where?
In 1D.
Oh, she's doing the Shields case in front of Judge Emerson.
Sounds like it, yes. I'm trying to work this case out.
Okay.
I understand that the state is brand new to this.
But let the state roll with it, or, I mean, so should we tell Mr. Jones we're gonna do Ms. Honholt
I
first?
saw him at the jail yesterday, so he knows what we're doing.
Okay,
Hey, how are you? Good to see you.
all right, let me pull up Mr. Jones's case.
Hold on.
She said.
She said okay, cool. I'm sorry. Mhm.
All right, so are we today just gonna talk about the bench warrant, or you think we can work the whole thing out?
A plea, Judge. Non-negotiated.
Well, if
okay.
if you're satisfied with me kind of going a little bit, stream of consciousness while because I'm looking at our notes to see what the victim contact is and where all the parts and pieces are. If Ms. Wood would prefer to go non-negotiated, I'm fine with that as well.
I'm good with whatever. Let me just check in with Mr. Jones. Mr. Jones, I'm Judge McBurney. We've never met.
How you do?
I'm doing okay. Your case is assigned to me, and it sounds like Ms. Wood, working hard on your behalf, is thinking this is a case that we actually can work out, close it out, and not just worry about, oh, maybe I reinstate the bond. You're from Alabama. Are you really coming back? And this and that. We have a prosecutor who is visiting us. This is not her normal assignment, because the regular prosecutor's stuck in trial in another courtroom. I'm fine, giving everyone a couple minutes to sort this out, to see if we can bring you that closure. Are you good with that?
I'm good with
Okay.
I trust them.
Okay, Ms. Williams, would it help if you have 5 more minutes?
That might help, Your Honor.
Okay.
I've got everything pulled up.
Take 5 minutes and digest.
Okay.
And I'm gonna go back there, and then I'll come back out, and we'll get you right back out here, Mr. Jones, and take care of business, okay? All right.
Thanks, Judge.
You bet. And I really will go away. You can get him back there. With Ms. Honholt, you're along for the ride, or have you all made up?
Well, so she left me the reason I had her brought over on Friday is because she left me a very long voicemail that morning, firing me and letting me know that she was ready to accept the state's offer and that she would do it herself. So I haven't spoken to her since then.
Okay.
I got another voicemail from her this morning. Someone has broken her glasses and she's very upset about it. I don't remember her having glasses.
Probably Deputy Gordon.
Probably.
Yeah.
So I'm letting you know.
Okay.
That's the next thing.
All right. I have water for her. I don't have glasses. I'm not gonna be able to help with that. All right. Sir, are you here for a case that we haven't brought out? What are you here for?
I'm with Miss Ruff, or it was the
Oh, you're Mr. Samson?
Yes, Your Honor.
Oh, okay. I didn't see you on the calendar. Is Ms. Ruff coming, or is she on the?
She just stepped out.
Okay. You all maybe have worked something out?
Yes, sir.
I won't get to see you on Monday. All right. I'm up for that. Okay.
Yes, Judge, I had written it in on Outlook. I'm sorry.
That's okay. I'm sure you did. I didn't see it. That's great, because I was recognizing the gentleman back here. I can't place him. And then there was something weird going on with that lady's cell phone. Like, he's being helpful. All right. We'll do that today as well. Maybe before Ms. Honholt. All right. I'll come back in about 5 minutes.
Thank you, Judge.
Who? Oh.
Say 5 minutes up.
Yeah, I mean, I can, if that's too long, I just want to give Ms. Williams a chance. She is nailing this, which is great. I just want to give her time. So is 5 too long?
No, I was just gonna run too long down.
How about this? Why don't you just get me, if that's gonna be 5-ish minutes, tell me after you've done that.
Okay.
All right?
She wants me to be. Okay. Yeah, okay, okay. Yeah, he actually had a free cameras. Okay, excellent, thank you. I ran all right. Listen. I don't like going either. I don't like going either. Literally say less. It's fine. Okay. Mm-hmm. I would love. She always offers snacks. Blood sugar just dropped. Do you need any? Oh, that would be, thank you so much.
I didn't put my hand on it.
No, it's
I
fine.
just
I'm gonna,
put it out.
yeah. Oh, yeah, because that plea was.
Yeah, the continuous glucose monitor kept going off. I was like, oh, let me go wash my hands and eat.
Thank you so much. I appreciate it.
We can get that door. Hey, Joe, yeah, please. Still need some more time as, in.
We can roll with it.
Okay.
Ms. Wood. We'll work it
I
out.
think he was like stopped on the scene, right? Or like, I don't think he
Yeah.
got very far.
And so how much time has he served already?
Let's see. He did when he was first arrested.
So clearly, yes, I do need some more time because I'm still talking.
Good? Say two.
Oh my God, I literally wrote it out for myself. It was like right over 4 months. Oh, here we go. From February to July 2023, and then he was released to a hold in Alabama. He went there, then he went to prison in Alabama. He got out of prison.
Passionate.
Yes, and it was like late last fall. And then he actually missed court. So I was just trying to ask him, I'm like, did you miss court while you were in prison? And like, and he wasn't sure because his family member was getting his mail for him. And so, yeah, so then he went to check in with his parole officer in Alabama, and they're like, oh, we got a warrant in Fulton.
So with his compassion release, is he on parole, probation, is on?
He's on parole in Alabama. So, what'd you say?
Don't get parole out of Alabama?
No, he did get parole.
Oh.
Yeah.
Wait for the role, whatever Alabama's doing.
Well, just because you can do the transfer thing, but I think it makes the most sense for us to do like a suspended sentence and not bother with all of that. What?
Okay.
You wouldn't have to do it though if it was suspended sentence, right?
No.
Okay. I think that makes the most sense.
Can we banish him from the state, from Fulton County?
Yeah, if we do a suspended sentence, we can put a banishment under there. So I think that makes the most sense.
Let's do it. How much longer does he have on parole?
I think he said 2 years,
Okay,
something like that.
so, is this his only case? Do I need to
Mhm.
check? Okay.
That's all I saw for Fulton. Did you have anything for him? Yeah, I think
Okay.
all of his, so what happened is he like randomly landed in Atlanta and didn't have anywhere to go. And so he was just like on the street. And that's what happened with this case is he went into
Okay,
a mailroom.
so let's do, can we do 3 years suspension?
Yeah.
Banishment from Fulton.
I'm good with that.
All right.
Thank you.
Thank you.
Like he's been having bad trouble with people going out of state.
I know. I'm like, please, Lord, let's just do this so I don't have to fool with it. Because I can only imagine.
I can't, I'm not acting right.
Ugh, adding more work.
Yeah, so that works. That'll work.
Perfect. Do you have, what's happening in the other case that you have?
Mr. Smith. So she said, reduced to misdemeanor of grade, 12 months probation.
Nice.
Yeah.
Okay.
She sent me,
Okay, oh, thank you.
Thank you. And so just to confirm, you said that Mr. Rhodes was not brought over.
That's correct.
Okay.
He is still in DeKalb County Jail. So. Oh, I know, and she's been at every court date. I'm gonna talk to my social worker and see.
I was wondering that, because I mean, you know, we have weeks in there.
Yeah.
So I was just.
No, that's a good question. So many times we don't have any family to work with, but she's different in that she's been very plugged in and she goes to every single court date. So.
Okay.
What courtroom are you normally in? Oh, nice. How is she?
She's great.
She seems so pleasant. I've never been in front of her. I like
So
have,
lovely.
yeah, I was about to say, like, I've only ever heard good things about
It's the
her.
right place to be.
I've said twice. She's so perky.
That's, oh my gosh, that's awesome. I'd heard that she was retiring, but I guess that's not
She
true.
don't look like she going anywhere.
Okay.
She says, they're supposed to.
So is it one of those where she like says it and then it keeps like?
Yeah, because her court also like, she keeps saying it.
Yeah, this last one, she said she said January 3rd, 2026. She said that's
That's
the day.
it?
That's the day. That's what she said.
I got just for you next week.
How does this happen to you?
Clearly that lady likes me. Oh, and then she shot me an email last week. It was like, hey, FYI, we're gonna take some pleas on the 19th. I was like, okay, so what, 16th? Okay. She emailed me this morning. She was like, hey, they changed their mind instead of she's doing a whole calendar.
Oh my goodness.
Yeah,
She was like, are you gonna cover this?
Oh my gosh.
we got it together. We got it together.
So, does she start on time?
She baby.
Okay.
Pretty much. She's
Yeah.
so I kind of judges paperwork and I handle her. And it's like that.
No way.
Because judge hates papers.
Yeah.
So everything we do is electronic. We just talk news now. And I'm gonna show you a understand. Yeah. Good. Electronic. Like,
Yeah.
I don't even.
So much easier.
You can just scan them.
Yeah.
It's like, yeah, no, I can do that.
Oh my gosh.
Now, yeah. Hey, everything is fine, so you can go ahead and come and pick it up.
Are you serious? That's wild.
So then I sent her to early termination and the ADA had already signed.
Mm.
So all you gotta do is just sign it so that we can go back.
Oh no.
I get an email yesterday. She said she has some questions about it. So we're gonna add them to the calendar for next week.
Oh no.
I emailed the office and, hey, I need you. I'm up in court next week.
Yeah, no, for real though.
I need you to pop up in court next week.
What day is it, did you say?
We got pleas on the 19th, and then she's
Okay.
got 2 revocation calendars on the 20th.
Yikes.
So, yeah. That's gonna be my week next week.
Yeah.
I told him.
Oh, we do? Oh, yeah. What would they look?
Are we good to go on Mr. Jones?
Yes, we have a negotiated plea now, Judge.
We'll see what time buys you. Thank you again, Ms. Williams.
Thank you, Judge.
Ms. Davis owes you. Where are you normally parked? What, in which courtroom? Yeah.
Oh, Judge Barley.
All right. So you're just down the hall.
Right, absolutely.
Okay, here's the note. You send it back to the bank.
Do you want to be at the witness stand, or do you want to be at prosecution table? I just need to turn on the right. Okay, great. Just need to turn on the right camera so Ms. Rivers can see and hear you.
Thank you.
Ms. Davis sits there. You're welcome to stand. It's A-OK. There we go. Excellent. Ms. Rivers, you good?
Yes, Judge, I'm ready.
Excellent. This is position 3 on our inquiry calendar, State versus Tracy Jones, 24 SC 005-326. Mr. Jones is here in court with his lawyer, Ms. Wood, and we have Ms. Williams representing the state. And Mr. Jones, because of the extra 5 or 6 minutes we took, it sounds like we now have a negotiated plea, which means the 2 sides are going to be recommending the same sentence to me. You're going to be put under oath in just a minute, answer a bunch of questions. If at any point you've got a question of your own because you don't understand what's going on or you're curious about something, will you let me know?
Yes, sir.
Last thing for now from me, at the end, I will impose a sentence. If the sentence that I impose is more than what Ms. Wood asked for, you'll have the right to withdraw your plea. So if for some reason I'm going to do something that's more severe, I'll tell you, like I'm making it up. If she says 6 months probation, and I say, nah, it needs to be 8, I'll tell you that. And then I'll give you a chance to talk with Ms. Wood and say, that's not what I want, but I'll stick with that. Or no, thank you. Let's head in a different direction. Okay. All right, Ms. Williams, when you're ready.
Thank you, Judge. Mr. Jones, hello, how are you, sir?
How you doing?
Can you hear me okay?
Yes, ma'am.
Excellent. I'm going to go through, as the judge said, just a lot of questions with you. Some of them may seem repetitive, but just bear with me.
Yes, ma'am.
I'm going to begin by asking you to please raise your right hand. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes, ma'am.
You may lower your hand, sir. Thank you. Could you please state and spell for the record your full legal name?
Tracy Brian Jones.
Could you spell that, please?
Tracy, Tracy, Brian, Bryan, Jones, Jones.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am. I mean, is you talking about mood altering or something like that?
Or anything. You take aspirin, you take.
Oh, yeah, I'm on like 23 different medicines I ain't been able to take in 40 days.
Okay.
You've been in jail for about 40 days?
They've been holding me in Elmore for 40 days for Georgia.
Okay. But it sounds like you knew where Ms. Williams was heading. You normally do take certain medications, but none of it is mind altering.
No, sir.
Okay. So you're able to follow what we're doing here?
Yes, sir. Yes, ma'am.
Excellent. How old are you, sir?
I'm 53.
How far have you gone in school?
I went to the 9th grade and got my GED and went to some college and took trade school.
Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Thank you, sir. Ms. Wood, on behalf of your client, do you waive formal reading of the indictment?
We do.
Mr. Jones, do you understand that you are currently charged with the following offenses in indictment 24 SC 005326? You are charged with count 1, burglary in the second degree, count 2, criminal damage to property in the second degree, count 3, criminal damage to property in the second degree, and finally, count 4, possession of tools for commission of a crime. Do you understand those are the charges against you?
Yes, ma'am.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes, ma'am.
Have you had enough time to speak with Ms. Wood about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss anything about the case with Ms. Wood?
No, ma'am.
And if you have any questions during this time, you can stop me and
Yes,
ask
ma'am.
Ms. Wood. Are you satisfied with Ms. Wood's services?
Yes, ma'am.
Ms. Wood, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
We do.
Ms. Wood, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
I do not.
Thank you. Mr. Jones, as to the minimum and maximum sentence for the charges against you, for count 1, the minimum sentence is 1 year, the maximum is 5. That is for burglary in the second degree. For count 2, criminal damage to property in the second degree, minimum is 1 year, the maximum is 5 years. For count 3, criminal damage to property in the second degree, again, that is 1 year to 5 years. And finally, for count 4, possession of tools for commission of a crime, that sentence range is 1 year to a maximum of 5 years.
Yes, ma'am.
Okay. And again, just to repeat what the judge has said, do you understand that this is a negotiated plea of guilty, which means that Ms. Wood and I have discussed and we will make a joint recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences one after the other.
Yes, ma'am.
As to the actual terms of the recommendation, Your Honor, for all 4 counts, we are recommending the same sentence that to all run concurrent, and that sentence would be 3 years, suspended sentence, conditioned upon Mr. Jones being banned from Fulton County.
Stay out of it.
Ms. Wood has some additional explanation that she'll provide later as to why.
She always does. But it's basically, it's a 3-year sentence, but it's a suspended sentence.
Yes, Your Honor.
Okay.
And that would be 3 years in custody, suspended. Mr. Jones, having heard the terms of the recommendation, do you wish to proceed with the plea?
Yes, ma'am.
Sir, do you understand that this plea may be used to enhance sentencing on other convictions in this state as well as in other states and in the federal courts?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
If you are not, entering a guilty plea will affect your immigration status and will result in deportation regardless of any advice given by your attorney or anyone else. Do you understand that?
Yes, ma'am.
Do you understand that there could be other things that happen as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and/or your right to receive, possess, or transport a firearm.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
I'm now going to go over your individual rights that you're waiving. Do you understand that you have the right to plead not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, this matter could proceed to trial?
Yes, ma'am.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury
Yes, ma'am.
and also the right to remain silent and not incriminate yourself,
Yes, ma'am.
and also the right to confront witnesses against you,
Yes, ma'am.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
as well as the right to the presumption of innocence,
Yes, ma'am.
as well as the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
as well as the right to subpoena witnesses and compel the production of evidence.
Yes, ma'am.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that you are also giving up the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights we've just discussed and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 24SC005326, how do you plead to count 1 burglary in the second degree?
Guilty.
How do you plead to count 2 criminal damage to property in the second degree?
Guilty.
How do you plead to count 3 criminal damage to property in the second degree?
Guilty.
And finally, how do you plead to count 4 possession of tools for commission of a crime?
Guilty.
Thank you, sir. Is the guilty plea that you've just entered given freely and voluntarily with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition, which would challenge the voluntariness of this guilty plea?
Yes, ma'am.
Do you understand that the appeals and petitions we've just discussed must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
And finally, do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Thank you, sir. That concludes all of the questions that I have for you.
Thank you, ma'am.
Now, where do we go next? Where do I go?
Factual basis, you tell me what happened on February 10th of 2023 at the Arrive Buckhead apartment complex?
Yes, Your Honor. That is, the incident date is February the 10th, 2023. The incident location, as you said, is Arrive Buckhead. That is located at 740 Sidney, Sidney Marcus, common spelling Boulevard Northeast. That is within the bounds of Fulton County. The property manager contacted APD officers because Mr. Jones had been detained by the courtesy officer. They had observed on previous occasions someone walking into the fitness room to get to the mail room, to get to packages and boxes. And so the property manager stated that she had asked the courtesy officer to watch the video cameras and then to go to that area at about the same time. And at that time, Mr. Jones was using a blue crowbar to force entry inside of the fitness room. And then he made his way to the mail room and began to use the crowbar to break into specifically 9 packages and taking 4 packages out of the boxes. Mr. Jones was he then attempted to flee, but he was detained shortly after. Officers obtained the footage, and after being taken to Grady, he was taken into custody.
All right. Anything else from the state?
No, Your Honor, nothing further from the state.
And
That's what you accept the plea.
right, which is 3 years suspended, stay out of Fulton County.
Yes.
All right, I think I got that. Let's check with Ms. Jackson. Ms. Jackson, do you have criminal history information on Mr. Jones?
Yes, Your Honor. There are 29 cycles. The last arrest was May the 31st, 2024. I think it's Autauga, Autuga, Alabama, for 3 counts of alias writ. And that case appears to be still pending. Also, he appears to have an open case pending in Tallapoosa, Alabama, for obstructing justice. And there appears to be an open case pending in Prattville, Alabama, for dangerous drugs and theft by
That's all what I'm
child.
on probation for now.
He does have prior felony convictions, one in 2001 out of Alabama for felony escape, one in 1994 out of Alabama for robbery. He does have misdemeanor convictions, one in 2020 out of Alabama for theft of property, one in 2018 out of Alabama for possession of drug paraphernalia, one in 2014 out of Alabama for public intoxication. Nothing in addition, Your Honor.
Thank you so much. Ms. Wood.
Yes, Judge. So I'm going to set the scene for us. He was arrested on February 10th, 2023. He served 148 days. The case was actually dismissed at the preliminary hearing stage in June of 2023. He had a hold for the Alabama cases, so he sat here until July the 7th of 2023. He was then picked up, taken to Elmore County, Alabama. He sat in that county jail, and then he went to the Department of Corrections in Alabama up until sometime last fall. It is my understanding he was released on parole under compassionate grounds. He is suffering from cirrhosis of the liver. He's awaiting a liver transplant. We obviously hope that he's able to get that. Those open cases that pretrial services mentioned, I believe those are closed. I believe he resolved those and they sent him to prison. He was actually reporting to his parole officer in Alabama like he's supposed to, and then this warrant from December's arraignment court date popped up. And so that's the amount of time that he was talking about. He sat and waited for extradition.
Sure.
Is for this. Judge, he actually did a sobriety program in the Department of Corrections in Alabama. So he tells me now he no longer struggles with alcoholism. That is what he was struggling with at the time. He ended up just taking Greyhound, ended up in Atlanta. He has no ties here. And so unfortunately, that's what led to this crime. He obviously wants to get back to Alabama. He's 53 years old. All of his ties are there. He has a stable place to live. He's going to live with his mom, Sandra Davis, in Millbrook, Alabama. So I think in the spirit of judicial economy, it makes the most sense. And we would ask you accept our joint recommendation, Judge.
Okay. I think it does make sense. Mr. Jones, I'm sorry to hear about the liver. That's not an easy one. But maybe the alcohol abuse treatment you got while in custody, coupled with the fact that you're going to kill yourself if you keep drinking, will help when you get out. Tell me why you came here on a bus as opposed to going to Dallas or Tulsa.
When I got diagnosed, they gave me 18 months to live, and I kind of
That's hard news to get.
I kind of gave up, and I got into it with my family. And I didn't have no ride or nothing when I left home. So I jumped on a train going down the track. And I just said the first place it stops, that's where I live. And it was here in Atlanta. I lived in the woods and under the bridges for about a year and a half. Got back on drugs and got with the wrong people, and I ain't had nothing else to live for. I guess, like I said, I gave up. When I got locked back up and I went back to prison, my family got back with me, and I was able to get a compassionate parole release, which I'm still on parole and probation, and I have to do a call in, a color code. I have to call every day and see if my color comes up, and if it does, I have to go and take a urine test. But here recently, I've got my disability check back, my Medicaid, getting all my medicine.
So you're back on track.
Yes, sir.
And your family's there again.
They're wide open with me.
Well, that's what family's supposed to do. All right. Well, that helps me. That paints a more complete picture of what was going on. I thought we were gone with the days where people hop on a train and see where it takes them. Look at you, original hobo. it sounds like you don't have any connections to Atlanta. So if I have a condition that basically says stay out of Georgia with a little pocket that you can go to, that's not going to make your treatment or recovery complicated or being with family. Everything is in Alabama?
Yes, sir.
Okay. All right. Well, I appreciate you sharing what you shared. I didn't mean to push you into an emotional space, but it helps me understand a more complete picture. Mr. Jones, I find there is a factual basis for your plea. And you and your blue crowbar did what you did at this place.
Yes, sir.
I also find that your plea is knowing and voluntary. You understand what we're talking about, and no one's forcing you to enter this plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Williams, can we sign for you?
Yes, Judge.
And is it all right if we electronically sign your name to the indictment indicating your plea?
Yes, sir.
All right. I didn't hear anything, Ms. Williams, about restitution. I'm assuming enough time has passed. We're not looking at that?
Yes, Judge.
Okay. Mr. Jones, I'm going to sentence you on each of the 4 counts to 5 years to serve 5 months with the balance suspended. You've served more than 5 months, but very cleanly in the time you were here after you got arrested till you bonded out, really, which you got sent back to Alabama, and then the few days you've been here, that's 5 months. So those are your 5 months. I'm doing more than just the 3 years because it's all suspended. No one's going to supervise you. I just want to build the longest possible time where we can say, you stay there and don't come here.
Yes.
Your special conditions of your suspended sentence are only 2. One is to obey the laws of the 50 states and the United States. Don't get arrested. And the other is that you are banished from the state of Georgia, except for the Chattahoochee Circuit, which is some counties around Columbus.
I'm staying in Alabama.
That's fine. But I can't banish you from the entire state. I'm not allowed to do that. And so I'm giving you your landing pad, if you wanted to, is it's fine to go to Columbus, if you're thinking about it. Columbus is a safe city. Don't go past Columbus, because then you're running into, I'm in a part of Georgia I can't be in. So you can be in the Chattahoochee Circuit, but no other judicial circuit.
Yes.
Okay, but it sounds like Alabama is where you want to be and need to be. Ms. Wood, anything else on behalf of Mr. Jones?
No, Your Honor, thank you.
Ms. Williams?
No, Your Honor.
So, Mr. Jones, I will sign your final disposition probably today, although it's getting late. If not tomorrow, you should, don't quote me, be out by Friday. Do not get mad at Ms. Wood if you're not out on Friday. That's not on her. But no one wants to keep you here any longer. How are you getting home? Because there's not a pipe we push you into to get back to.
You need to call somebody for you?
Yeah, probably need one because they brought me on transport.
Right.
Right.
And I don't have no money.
Right. So I don't think the sheriff gives you a bus ticket. He might give you a MARTA ticket, but MARTA will only get you a little ways west, and then it's a long walk. So
I could call my brother, and my brother would.
Okay, just be working on it because technically you're violating your sentence when you get out and you're in.
Before I left,
no one's going to grab you. No one's going to grab you. That'll kick in a week or so. All right.
Okay.
All right. Good luck.
Thank you so much.
Do you need to call your brother for you? Here's my number.
Well,
You got it at address?
somebody.
Okay.
Should we do Mr. Samson?
Thank you, Jan.
You bet. Take care of that liver. I don't have my trial calendar out here. Oh, I can find it. That's okay. You can just tell me.
23 SB 188-011.
Thank you.
From the email we got yesterday, I think you said he was number 3.
Yeah, well, I was going to look at that email because that had the indictment number, but Ms. Simpson was there.
And I assume with the other pleas that he was going to be next. So we talked about that and able to reach an agreement.
Okay. Right, because cases were going away.
Yes.
And we'll handle this now anyway. You're ready to go on this case too?
Yes, Judge, I'm gonna be doing a little bit of stream of consciousness on the factual basis, but I'll keep it short.
Okay. Let me get one document up on the screen and then we'll get going. Okay. This is 23 SC 188011. And it is the state versus Melvin Samson. Mr. Samson is here with his lawyer, Ms. Rupp. We've got Ms. Williams here for the state. And Mr. Samson, you've sat through a bunch of pleas now. I don't think yours is going to be quite like Mr. Davis's, but you understand the process. Ms. Williams is going to ask you a bunch of questions. You answer those. Any point you've got a question, we need to stop and see if we can answer that question. Okay?
Okay. Yeah.
All right, Ms. Williams.
Thank you, Judge. Mr. Sampson, I'm going to begin by asking you to please raise your right hand. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, sir. You may lower your hand. Please say and spell for the record your full legal name.
Melvin Tyrone Samson Jr. And that's MELVIN SAMPSON.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, man.
Is there a medication that you normally take that you have not been given today?
No, I don't.
How old are you, sir?
31.
How far have you gone in school?
Sophomore year of college.
Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Ms. Ruff? Okay, Ms. Ruff, on behalf of your client, do you waive formal reading of the indictment?
I do.
Mr. Sampson, do you understand that you are charged with the following offenses?
Just one. Aggravated assault.
Do you understand that you are charged with aggravated assault?
Yes, ma'am.
And do you understand that that carries a sentence range of 1 year to 20 years?
Yes, ma'am.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes, I have.
Have you had enough time to speak with Ms. Ruff about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes, I have.
Do you need to talk to Ms. Ruff about anything involved in the case right now?
No, I don't.
Are you satisfied with her services?
Yes, I am.
Ms. Ruff, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
The state is unaware of any outstanding warrants related to these charges. Ms. Ruff, do you know of any?
No.
Sir, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences one after the other.
Yes.
As to the actual terms of the recommendation, the state will reduce the charge to misdemeanor affray with a recommended sentence of 12 months probation, during which time Mr. Sampson must take an anger management class, complete 40 hours of community service, and have no further violent or harassing contact with the victim. Tyquan, Tyquan, Gerald, Gerald hyphen Bly, BLY. Tyquan Gerald hyphen Bly. Having heard the terms of this joint recommendation, Mr. Sampson, do you wish to proceed with the plea?
Yes.
Even though you are entering a plea, if the court accepts it, to a misdemeanor, do you understand that the plea could be used to enhance sentencing on other convictions in this state as well as in other states and in the federal courts?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a U.S. citizen?
Yes.
If you are not, entering a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else. Do you understand that?
Yes.
You are entering, if the court accepts it, you would be entering a plea to a misdemeanor. So even though it's unlikely, do you understand that there could be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect such things as your ability to obtain employment or your ability to lease an apartment.
Yes.
I'm now going to go over the individual rights that you're giving up. Sir, do you understand that you have the right to plead not guilty?
Yes.
Do you understand that if you plead not guilty or remain silent, this matter could proceed to trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury?
Yes.
Do you understand that you are giving up the right to remain silent and not incriminate yourself,
Yes.
as well as the right to confront witnesses against you,
Yes.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
as well as the right to the presumption of innocence,
Yes.
as well as the right to testify on your own behalf and to present other evidence,
Yes.
as well as the right to subpoena witnesses and compel the production of evidence.
Yes.
And finally, as well as the right to have the charges against you proved by the state beyond a reasonable doubt.
Yes.
And finally, you are also giving up the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, it has.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 23SC188011, how do you plead to the charge of misdemeanor affray?
Guilty.
Is the guilty plea that you've just entered freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge or 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Do you understand that the appeals and petitions we've just discussed must be filed by your attorney unless you are representing yourself?
Yes.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Mr. Samson, that concludes all of the questions and information I have for you. Your Honor, I will now provide a factual basis for the plea.
My understanding is that the allegation is that on July 3rd of 2021, Mr. Sampson and Mr. Gerald Bly got into some altercation that resulted in Mr. Sampson allegedly stabbing Mr. Gerald Bly with a kitchen knife.
Yes, Your Honor. That is the basics of what happened. The location being 1706 Crest, common spelling Ridge, common spelling Drive. That is in East Point, Georgia, which is within the bounds of Fulton County.
Okay. Anything in your file showing whether Mr. Gerald Bly had to be rushed to the emergency room and remove a knife from his heart, or it was a cut and it was bleeding, but he didn't even leave with the EMTs?
It looked like he received several stitches from his index finger to his thumb and stitches on his right forearm.
Okay. So it did require some medical attention, but it doesn't sound like it was life-threatening.
Correct, Your Honor.
Okay. All right. And I know you've been stuck here in court all afternoon. Any sense of whether your office has had contact with Mr. Gerald Bly to get his perspective on this?
It appears, Your Honor, that we have had difficulty reaching the victim in this matter.
Okay.
We've tried to contact him a few times. The telephone number has not been in service and we've been unable to reach him.
All right. Thank you so much. Ms. Jackson, do you have any criminal history information as to Mr. Sampson?
Yes, Your Honor. There are 14 cycles. The last arrest was March the 12th, 2025, out of Cobb County for a probation violation. He does appear to be on probation in Cobb County for 2 counts of fleeing or attempting to elude an officer. That disposition date was March the 13th, 2023, and the term is for 4 years and 6 months. There's a misdemeanor conviction and sentences. There was a conviction in 2023 out of Cobb County for driving while license suspended or revoked. He received a nolo contendere sentence in 2023 out of Smyrna, Georgia, for driving while license suspended or revoked. He received a nolo contendere sentence in 2022 out of Cherokee County for driving while license suspended or revoked. He received first offender treatment in 2015 out of Cobb County for theft by taking. That case was sealed November the 9th, 2016. Nothing in addition, Your Honor.
Thank you. Mr. Samson, I'm going to hear from Ms. Ruff in just a moment and then from you about this case, but tell me the status of your license now.
It's valid.
You paid off fines or whatever you needed to do?
Yeah, I paid that off.
How long has it been valid?
Since, well, when I got out in like March, so like a few months.
When you got out in March of this year?
Yes, Your Honor.
For this Cobb case?
Yeah, for the probation violation.
And what was the basis of the violation?
It was something with he said I didn't call or something to check in with the PO.
Okay.
I represented him. It was this case, Your Honor.
It was this case?
Yes, and
Got
he
it.
was held here and then he was transferred to Cobb. And then I went and represented him there. And then they, the solicitor there we worked out and based upon how long he had been in jail, they decided to go ahead and release him and return him back to probation.
Okay.
And so that he could come here then and face that. And I believe he has one more ticket in Clayton County that I will be clearing up.
Well, you're going to lose a lot of business if he keeps his license current. That's good for
Well,
him, bad for you.
You know, you might remember we were here earlier. I did try to withdraw, but
Yeah.
I went full mom mode on him. and
Thank you.
He's here. So.
All right. Ms. Simpson, you've got Mr. Sampson in your system as being on probation on his Cobb case. Is that it?
Yes, this basic act was not based on this modification. It was actually for failure to report and for career.
Okay. All right. Either way, and this won't change it because the thing you went onto probation for is a recent conviction. In this case, the criminal conduct is very, very old, so it's not going to have an impact on your probation. What do you want to tell me, Ms. Ruff, about the case, about Mr. Sampson?
So to begin with the case, Your Honor, Mr. Sampson and his cousin, they are blood relatives. Their grandmothers are sisters.
And Mr. Gerald Bly is the cousin?
Yes.
Okay.
And so they were at his sister's apartment, and unfortunately, a little bit of tequila got involved. And they were getting into it and fighting and wrestling. Both of them were taken to Grady, and he also has stitches that he received. He does not remember having a knife. He does not remember stabbing him. He doesn't know who grabbed the knife first. I do know that from the report, Mr. Gerald Bly just started drunk ramblings on the way to the hospital. So to me, it's still unclear as to who had it, but Mr. Sampson does maintain that he was attacked by his cousin, but he was on crutches. He had just had surgery. So we've talked a lot about him definitely staying out of trouble. Some of the very early on arrests that he had were while he was still in college, and I don't know if I just remember the boys in my college just trying to be tough and stupid. But so he has pledged to stay out of trouble now, and he's gotten his license. We're working with him on his his other things, but the reason why I did approach the state about a fray is because I wanted to, he wanted to acknowledge that it wasn't appropriate to be fighting with his cousin, whether it was inside, but it did spill to the outside of the apartment complex where they were.
All right. It sounds like, Mr. Samson, that Mr. Gerald Bly is someone you still encounter from time to time, because the condition wasn't no contact with him, it was just no violent contact with him. Is that true?
Yeah, no, we don't talk though. Like, we
Okay.
don't see each other at events or stuff like that.
You said you do or you
We
don't?
do not.
Oh, okay.
That's what he's maintained the entire time, is that
Because I thought it was just contact.
he thought he couldn't have any contact.
Oh, probably the condition of the bond was no contact at all, and that's good. That's how it needed to be. But your bond is about to go away, and you're entering a plea. And so I'm looking forward to what should the format be. And if your grandmothers are sisters, then I could see there's an event where your cousin's going to be there, and you want to be able to go. But I don't know. He may have moved to Alaska, and then it really doesn't matter about the contact. Is he still local?
Yeah, no, he still lives in Georgia.
Okay, all right. And is your extended family such that it's possible in the next year you and he might be at the same event?
It's a possibility.
Okay.
But I'm
Do you
not-
guys move in the same circles in
Nah,
terms
not
of
really.
friends?
Like I said, ever since this whole thing took place, it's kind of like I don't have any cause to be around him.
Okay. Where's home for you? What city?
It's Atlanta.
Okay. And where's home for him?
It's Atlanta.
Okay. All right. Do you have any questions about anything we discussed?
No, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I'm a chef, cook.
Where are you a chef? Oh, we talked about this.
Yes, Your Honor.
Yeah. All right. So you're a chef. How long have you been doing that?
For over 10 years now.
Okay. It's a long time. Kids?
Yes, I have one daughter.
Okay. Does she stay with you?
Now she stays with her mother in Marietta.
Okay. All right. I don't have any other questions if you don't have anything you want to add.
No, I don't have anything in addition, Your Honor.
Okay. Well, I find there's a factual basis for your plea to a fray. It was clearly an affray, regardless of who started it. It became an affray. I also find that your plea is knowing and voluntary. Ms. Ruff, is it all right if Ms. Nelson from my office signs your name to the indictment?
Yes, Your Honor.
And Mr. Sampson, can we sign your name to the indictment?
Yes, sir.
Ms. Williams?
Yes, Your Honor.
We will do that. And I will follow the joint recommendation, sentence you to the one count, which is now a misdemeanor, to 12 months probation. Only 3 special conditions. One is that you complete an anger management course. Work with probation, they'll help you find one. You might find one of your own, but make sure that they bless that one before you pay for it and take it. You'll need to do 40 hours of community service. Similarly, you may find a place where you want to do your community service, and that may be okay with probation. Find out in advance that they're okay with it, as opposed to you show up saying, hey, I did 20 hours, and they say that's not an eligible, like working at your restaurant's not community service. And maybe most importantly, no violent contact with your cousin, Mr. Gerald Bly. So if you guys are at the same event, you don't have to walk away anymore, but you can't run up on him and chest bump him or stab him.
All right.
Okay. Ms. Williams, anything else?
No, Your Honor, nothing further on the state.
Ms. Ruff?
Nothing further.
All right. Mr. Sampson, you will get contacted either by Ms. Ruff or directly by misdemeanor probation about how to report. Most of the reporting is online or on the phone, but you may, for the first time, the initial sign up, need to go to their office, which is like 2 blocks from here.
Okay.
Okay. That's it. You don't need to stick around.
All right. Thank you, Your Honor.
You're welcome. Good luck with everything.
Thank you, Judge. May I be excused?
Yes, ma'am. Thank you. I do not need to see either of you on Monday, but you're welcome to come by.
Sounds good. No? Okay.
Nope, not all the way from Villa Rica.
Very, very polite, and I respect how you conduct your work, but I'm not gonna.
All right, got it. I think there's only one case left.
Yes, Judge.
All right. Whenever Deputy Gordon's ready. Okay.
Judge, can we have her at the podium and I think?
Yes, yes, yes. That's exactly how we'll do it. Ms. Davis owes you big time, depending on how this goes.
Okay. Well, I do love pink Starburst, so.
You're welcome.
This is the new one, you know, all impacts. I know.
Oh, I agree.
It's almost so cold that I drink lemonade.
Oh, no.
No. So Honholt is at the podium, Wood is at the table. Wood is currently fired, and we'll see if that changes. But where's your sidekick? Okay.
Will I need to relay the offer to her as well, or?
Oh,
I'll get it. I'll get it from you. I don't even know what we're doing today. We'll find out.
You know what? Is it okay if I just take a seat for a moment?
Sure.
Yep.
Hello, Ms. Honholt. If you'll come on up to the podium, and you can put your stuff on the podium, part of the podium, whatever works for you. Does it all fit? I don't want it to fall off. All right. So before we get on the record, I wanted to understand what you plan to do today. Ms. Wood relayed to me that you had contacted her with two messages. One, you're fired, but two, I will take the state's offer. I don't know what the offer is. I also know that Ms. Wood is right here, so she can continue to assist you if that's what you want. But really, the nub of it is whatever the state's offer was, and we can get that on the record in a minute. Is that something that you want to do, or do we start trial on Monday?
Well, if I relieve Lacey as my lawyer, then no. I mean, I won't be prepared for at least 5 months.
Okay.
Because it's snail mail, so I have to do everything.
It is not fast mail. That's true. So tell me what you think the state's offer was, and if that's something that you still want to do, because we can do that right now as well.
It was credit time served, no probation, no restitution.
So it would basically be released.
Well, I mean, I'm not going to be released. I still have 6 more years in prison.
From this situation, whatever it was, and then you've got your other business, but it closes out this case.
It closes out this case.
Okay. Tell me what the file, so this is Ms. Williams. I don't think you two have met. Ms. Davis, who was maybe prosecutor 3 on your case, is in trial right now. Ms. Williams is graciously covering, and so she's got Ms. Davis's paperwork, which really was Ms. Dilligard's paperwork. What does it show the offer is? Is it consistent with what you just heard?
So it's a bit different, and I'm happy to reach out to Ms. Davis just to confirm. But what I have in front of me, Ms. Honholt, is 1 year to serve concurrent with the current probation revocation in Gwinnett.
Okay, but you'd be entitled to time served, and you've served more than a year, so.
I'm not revocated from Gwinnett. I don't know what she's talking about.
Well, Ms. Williams is simply talking about what's in front of her.
I'm from Cherokee County.
So it could be Cherokee County. Were you revoked out of Cherokee?
Yeah, I was only revoked. All the other charges were dismissed against me, except this one.
Okay, so probably Ms. Davis meant Cherokee, but because she's second or third on the case, she put Gwinnett in there, but you know better than anyone. And my recollection was that we're borrowing you from Cherokee as well. I think we got you out of the state system, but originally it was Cherokee. So wherever you had the revocation, this would run concurrently with it, but we have to give you, and I would give you credit for the time you've been in connection with this case. If that's more than a year, then you actually are saying the same things.
It's been 2 years.
Okay, and I'm about to pull the case up. So it sounds like that offer remains the offer on the table. Is that something that you want to deal with today?
And what you said, no probation, right?
No, ma'am, there's nothing on here about probation.
And I'm only doing this because my sister wants this done.
Okay, well, you can do it for any reason you want, because God tells you, because you had bad cereal this morning, because your sister wants it. Ultimately, though, I'll be asking you, if we go forward with it, is this a decision you're making? No one's forcing you to do it. Yep, my sister wants me to do it. I agree with her. I'm going to do it, whatever. But I don't want you to go forward if you feel like I'm pushing one way or the other or anyone else. This needs to be a decision that you're making. I just shared with you what Ms. Wood relayed to me, which was you had said, hey, I'll take this, effectively, I'm gonna call it time served, this time served offer from the state so I can get on with my business. Is that a fair summary?
Yes,
Okay. So we can move forward.
but the last DA offered me credit time served, no probation, and no restitution.
Right. And that's what I heard Ms. Williams say.
No,
She said Gwinnett.
here.
There wouldn't be a sentence that's just credit for time served. I have to specify a number. 1 year, 1 year and 1 month, 10 years. I'm looking your case up right now so that I'm speaking more knowledgeably about the
I've been in
situation.
custody since August 10th of 2023.
Okay.
I got to Fulton County, September 16th, 2023.
So yes, you were committed to the Fulton jail in October of 23, and you're saying you have not been out since then?
No.
Okay, then, I mean, frankly, I could give you a year and a half, and you've already done that. I'm not interested in I mean, to hear more about the case and in disrupting the negotiations that were going on, but I have to actually put a number on the sentence. And so if I were to say, Ms. Honholt, I'm sentencing you to 1 year to serve, credit for time served, you have banked 1 year and 2 plus 10 months. You banked a year and almost 10 months, 9 and some change. And so if whatever sentence I pronounce is less than 1 year, equal to or less than 1 year and 9 months, it's credit for time served.
But would it be considered a prison sentence at 1 year?
It would be considered a custodial sentence. So let me just give.
That's where my problem lies with the custodial sentence, is because for some reason, the Department of Corrections does not like to give you custodial time for other counties. So it has to be specified that I've been incarcerated because that's what happened with my probation violation.
Mm-hmm.
I didn't get any of that time that I served because it was up to the custodian. And the custodian doesn't give it to you because it's the Department of Corrections.
Okay. So I recently had to go to judge training. Once a year, we have to do judge training, and was pointed towards a statute that was amended about 2 years ago. Some judges sometimes don't want to give credit for time that has been in custody. Just use your example. You were arrested in October of 23. And let's say you got out and then got arrested in Cherokee, did some time in Cherokee, and then came back to us. It's natural for a defendant to say, hey, I did some time in Cherokee. I want to get credit for that. And the judge in Fulton might say, but you were in custody in Cherokee for something different. I don't want to give you credit for that. And so I'm putting in this final disposition, no credit for that custodial time served. A law was amended to prevent judges from doing that.
Okay, well,
But you've been in jail longer than that amendment has been in effect. But it is in effect now, and it controls any sentence I would give. I'm not interested in not giving you credit.
So is that Senate Bill 535 or something like that?
It's got a number next to it. I don't know if it was a House bill or a Senate bill. Anyway, I'm telling you now, I cannot legally not give you credit for all the time you've been in since October 24th, 2023. But I'm not interested in not giving you credit for that. So whatever sentence I impose, if I impose a sentence, if it is 1 year and 9 months or less, then your Fulton County case is done, closed. Given that, and the fact that the state's recommendation is the 1 year, which is less than 1 year and 9 months, I'm prepared to go forward. I'm also fine having Ms. Wood pop back up here to do the lawyer part of it if you want that. But you are in the driver's seat in both ways. One, yep, she can come back up here. More importantly and fundamentally, yes, let's do this plea. I can answer the questions. Let's do it. I don't want to pressure. If you want to sit down and think about it for a few minutes.
Have you seen the pictures of have you looked at them?
So I don't want to go in that space. You need to decide. My sister's talked with me. I can close the door on this and move it. Or if I'm going to represent myself, then I got to go back to Lee Arundale or I think it was McRae.
The new prison.
Yeah, which I heard is a lot nicer than Lee Arundale.
It's interesting.
But it's a prison. So you can do that and let me know when you're ready for the trial. And I don't weigh in on which is the wiser choice.
Okay.
And you can also enter a plea under Alford where you are not admitting guilt, but it's in your best interest to go forward with the plea. And that doesn't change anything I do.
All right. I'll do that.
Okay. You want to go forward with an Alford plea?
Yes.
All right. Do you want Ms. Wood to stay where she is and you do this?
I can't believe I'm doing it. I mean,
You keep looking back at Ms. Wood, but you also told her no, thank you. So I need you to say yes, thank you, and she can come back. Or I'll have Ms. Williams start the conversation that we need to have if we're going to do the best interests plea.
all right, we'll just have that conversation.
Okay. If at some point you want to consult with Ms. Wood, I asked her to be here, sort of hybrid representation.
Can I just ask, can I just go in the hallway with her 1 minute?
Sure, you can have 2 minutes. And you don't even have to go in the hallway if you want. You can go back there or you can sit right there, whichever you'd prefer. If you're going to need to speak in raised voices, you should go back and lock up.
Okay.
Yes. You'll be done with Fulton County if you resolve this case today. Okay, jury can very well find you guilty. I think the jury could find you guilty. And it's not up to me. I'm not deciding.
Even when the blue came back, that it wasn't a match.
Yeah, I think it happens.
Okay. I can't risk it.
Okay, as in we should start?
Yep.
Okay. If you can come on back, please.
And then I have one more request after, as a birthday request.
Okay. I don't have cake, but I will listen to your request.
I mean, I didn't even get water the other day when you ordered it, so.
Here's how the process is going to work. In just a moment, Ms. Williams will put you under oath. She will ask you a bunch of questions about your rights and this and that. You need to answer all those questions to the best of your ability. And you need to let me know at any point if someone's saying something that you don't understand.
Okay.
I don't think they're going to be those kinds of things, but I don't know. So you let me know if you've got any questions about anything. Okay? All right. But let me get on the record that you are comfortable moving forward with Ms. Wood available in an advisory capacity, but you are taking the lead, if you will, in terms of the best interest plea. Yes?
Yes.
Okay. And every answer you give needs to be out loud because we've got a court reporter who you can't see because she's virtual, who needs to take things down, and she takes down the spoken word.
Okay.
All right? When you are ready, Ms. Williams.
Thank you, Judge. Ms. Honholt, am I pronouncing that correctly?
Yes.
Ms. Honholt. I'm Michelle Williams. I am, as the judge said, going to ask you a whole bunch of questions. Some of them may seem repetitive, but please bear with me. I'm going to begin by asking you to please raise your right hand as much as you're able. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Could you please say and spell for the record your full legal name?
Cynthia Lee Honholt.
Could you please spell that?
CYNTHIALEEHONHOLT.
Thank you, ma'am. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I take mental health meds.
Okay. Do those meds affect your ability to hear, perceive, or understand what I'm saying?
No.
And you wish to proceed with this plea?
Yes.
Is there a medication that you normally take that you have not been given today?
No.
How old are you, ma'am?
I will be 57 tomorrow.
Okay. How far have you gone in school?
I'm a college graduate.
Are you therefore able to read, write, and understand the English language?
Yes.
At this point, ma'am, do you wish to waive formal reading of the indictment?
Yes.
Do you understand that you are charged with the following offenses in indictment 24 SC 000792, count 1, identity fraud, which carries a sentence of 1 year to 10 years. Count 2, deposit account fraud, which carries a sentence of 1 year to 3 years or a fine of $500 to $5,000. And finally, count 3, forgery in the 3rd degree, which carries a sentence of 1 year to 5 years. Do you understand that?
Yes.
Have you had a chance to consider the rights that you are giving up by entering a plea of guilty today?
I don't know what that means.
Have you thought about what it means to enter a plea of guilty without going to trial?
No.
Let me intercede here. Ms. Williams is going to share with you in a minute a list of rights that you have as a criminal defendant, like the right to a trial by jury, the right to call witnesses on your behalf. Like you said, snail mail, you'd have some work you need to do things. So really her question is sort of out in front of all that. And so it may make more sense to ask at the end. But you do give up certain rights by pleading guilty. You don't have a trial. That's what a guilty plea is. No more trial. You aren't going to be able to call any witnesses because you pled guilty. So she's just foreshadowing the fact that she's about to ask you about the rights that you give up when you decide to enter a guilty plea. You understand that there are rights that you give up, which she'll detail in a moment, if you enter a guilty plea.
Okay.
You do?
No.
You do understand that?
I understand that.
Okay, great.
And if at any time you have any questions, you can stop me, okay, ma'am?
Okay.
Do you understand that an attorney reviewing your case might discover facts which might be helpful to you and might find that you have a defense to the charges or that there are mitigating circumstances which might be helpful to you? Basically, do you understand that an attorney might review the file and see things a bit differently than you might see them having reviewed your own evidence?
Yes.
And knowing this, do you wish to continue to represent yourself at this time?
Yes.
And I do believe, as the judge said, that Ms. Wood is sort of standing in an advisory capacity. Do you understand that?
Yes.
Do you wish to waive any and all, for the purposes of this plea only, do you wish to waive any and all defects in the indictment, including with respect to your name? And what that means is there might be a typo. There might be something like that that's wrong with the indictment, but for the purposes of entering a guilty plea, you waive all of those.
Yeah, I've never even seen an indictment.
Okay.
So.
Have you been arrested on these charges?
Yes.
Okay. I have to ask you that because the state does not know of any other outstanding warrants related to these charges. Do you happen to know if there could be any outstanding warrants?
Everything was dismissed.
Okay. I've just gone over the minimum and maximum sentence for each charge in the indictment. Did you have any questions about that?
No.
So this is, Ms. Honholt, a kind of a negotiated plea. The state and Ms. Wood negotiated to make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively, which means one after the other. Do you understand that?
Yes.
Okay. The actual terms of the recommendation, Your Honor and Ms. Honholt, are that for counts 1, 2, and 3, that Ms. Honholt be sentenced to 1 year to serve with credit for the time that she has already served, and that time in turn be concurrent with any probation revocation that she has going on in, I believe, Cherokee County.
Okay.
Ms. Honholt, having heard the terms of the recommendation, do you wish to proceed with the plea?
Yes.
Ma'am, do you understand that entering this plea could be, that by entering this plea, this guilty conviction, this conviction could be used to enhance sentencing on any other conviction that you get in the future? Not saying that you will ever be convicted of anything in the future, but should you be, this conviction right here could be used to increase the sentencing in Georgia and any other state, including the federal courts?
Yes, I will be leaving Georgia as soon as I'm released.
Understood, ma'am.
But it's true anywhere. You may leave Georgia to go to the state of Washington. If for some unfortunate reason you got sideways with the law in the state of Washington 5 years from now, this conviction could be used to make that situation worse for you. You understand that?
Mhm.
Yes?
Yes.
Okay.
Ma'am, are you a U.S. citizen?
Yes.
I must say, I must let you know that if you are not a U.S. citizen, this guilty plea conviction will affect your immigration status and will result in deportation. And that's true regardless of any advice by your attorney or anyone else. Ma'am, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, I don't carry guns.
I understood, ma'am. So as the judge said, I'm going to go over the individual rights that you're waiving right now. First of all, do you understand that you do have the right to plead not guilty?
Yes.
Do you understand that if you plead not guilty or remain silent, this matter could proceed to trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury?
Yes.
Do you understand that you are giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that you are giving up the right to confront witnesses against you?
Yes.
Do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that you are giving up the right to the presumption of innocence?
Yes.
Do you understand that you are giving up the right to testify on your own behalf and to present other evidence?
Yes. Sorry.
No, it's no problem. I can give you a moment.
There's no tissue over here.
Is that box empty?
Yeah.
We had quite the plea before yours, but I brought out another box. There you go, Deputy.
All right. Okay.
Okay. I think I've read this one, but let's start here. Do you understand that you are giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that you are giving up the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes.
And finally, do you understand that you are giving up the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
And did you have any questions about the rights that we just went over?
No.
Ma'am, are you pleading guilty because you have decided that it is in your best interest to do so?
No.
Well, let me explore that with you because I misunderstood then what I thought you wanted to do. My understanding is that you
Oh, I
contest
get
the
it.
state's case.
Never mind. I understand. Say that question again.
Okay, let's do it again. If you still have a question,
Mhm.
you the judge can continue to have that conversation with you. Is it your decision to waive all of those rights I just went over and enter a guilty plea because you have decided that it is in your best interest to do so?
Yes. I didn't hear the.
Okay. Therefore, are you asking the court to accept your plea as guilty under Alford?
That's the best interest. There is a U.S. Supreme Court case called North Carolina versus Alford, which was a big breakthrough in that it authorized a trial court to accept a guilty plea, even in the face of a defendant saying it didn't happen that way. I wasn't there, or it was self-defense, or it's a big misunderstanding. However, Judge, I've decided that it's in my best interest to enter a plea in this case because my sister's leaning on me, because I want to go home, because whatever it is. Your decision is your private decision. And up until that case, which is now very old, 50, 60 years old, a court couldn't say, but the defendant wants to resolve the case this way. If a defendant said, I disagree with some of the facts, fine, then you have to have a trial. I don't want a trial. A trial could be worse for me, or this isn't your situation, but I could go home today. If I wait for the trial, I'm stuck in jail for another year waiting on the trial. So for a host of reasons, all of which are personal, a defendant could say, I don't agree with what the state says happened in this case, but it's in my best interest, meaning yours, to enter a guilty plea. That's an Alford plea. That's lawyer shorthand.
So it's not like a no contest plea?
Nope.
No?
Nope.
Different?
It's different.
Okay.
So when Ms. Williams said, are you going forward with this Alford plea, that is equivalent to saying, are you going forward with the best interest plea?
Okay.
Oh, yes. So therefore, are you asking the court to accept your plea as guilty pursuant to North Carolina versus Alford?
Yes.
Are you aware? Well, I must inform you. How about that? I must inform you that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial. Do you understand that?
Yes.
And the court must approve your plea of guilty under Alford.
Okay.
As to indictment number 24 SC 000792, how do you plead to the charge to count one, identity fraud?
Guilty. Guilty.
Under
These are all under Alford. Okay. So you're going to say guilty. I know it's pursuant to Alford.
Thank you, Judge.
You bet.
Count 2, deposit account fraud.
Guilty.
Count 3, forgery third degree.
Guilty.
And those are all pursuant to North Carolina versus Alford.
Thank you, Judge. Is the Alford plea that you have just entered freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition which would challenge the voluntariness of this guilty plea?
Yes.
Do you understand that the appeals and petitions that we've just discussed must be filed by you because you are representing yourself?
Yes.
Ms. Honholt, that concludes all of the questions and information that I have for you. I will now turn to giving the court a factual basis for the plea. Your Honor, the incident date is August 24th, 2021. The location being Regions Bank at 1180 West Peachtree Street, and that is within the bounds of Fulton County. The victim's name is Barbara, B-A-R-B-A-R-A, Wolff, W-O-L-F-F. The branch manager of the Regions Bank contacted police after the defendant, who had previously been to that same branch, attempted to cash a check in the amount of $2,860, 2860. The defendant left before officers arrived. Officers were able to obtain security footage and used a photo pulled by the bank from an earlier transaction that happened there. Using that information, Ms. Honholt was identified as a suspect and subsequently arrested.
Okay. I appreciate that. Ms. Honholt, I'm going to turn to you now. I'm going to say a few things and then ask you a few questions and then let you share what you want to share. First, my understanding is, and Ms. Wood has made it plain from the beginning, you sometimes have made it plain as well, that you contest that the person caught in the footage and the still photo is not you, it's misidentification. And it reached the point where you were prepared to almost do a lineup of, here is Ms. Honholt in a certain state of undress. Look at this picture, and you can tell they're different people. And that may have been how a trial would go. But you've decided, after consulting with your sister and listening some to your lawyer, that it's in your best interest to take a time-served plea instead. An offered plea, I have already explained, is when a defendant says, I don't agree with everything the state says or anything the state says, but I, the defendant, believe that it's in the defendant's best interest to take this offer so that I can head in the direction I want to head in. And I can accept that offered plea. It's what you've tendered, and I'm prepared to accept it. But I also want to hear from you if there's anything that you think is important to say, not your birthday request. We'll save that till after we've put the final punctuation mark on things. But I do want to hear from you before I go through am I accepting it? Is there a factual basis, and what the sentence is?
Well, I mean, just on the police report alone that I have in my possession, I mean, I don't have my glasses, so I can't read it verbatim, but in the police report that I have, it did say that the face recognition was not a match, and the bank lady said she was only 80% positive that it was me in the, and I mean, I've gone over and over and over and over again about that girl not looking like me. I mean, she's at least 15 years younger than me. She has amazing boobs. And I mean, in the police report alone, it stated that they did a DDS face recognition and it was not a match of me. And that the bank teller lady was only 80% positive. And I mean, the girl had a tattoo on her arm. I don't have a tattoo on my arm. But as we're saying, that this is in the best interest, because it is a hardship for me to keep coming back out to court. I get my groove, and then all of a sudden I'm yanked back out to court. Now I'm 5.5 hours away from you guys. I'm all the way down south.
Yeah, where's McRae?
Far.
Okay. Somewhere in South Georgia.
Yes.
Okay. And you are there because of a revocation in Cherokee, and your charges in Cherokee were what?
Were a forgery of a car title. It was between my ex-boyfriend and I, and he was a federal agent.
Okay. And when you talk about other charges being dismissed,
they were all dismissed.
You were arrested in other jurisdictions for situations similar to what we're talking about here.
The situations those situations involved my son and his girlfriend. My son has since been murdered in Ohio in 2023.
Right. I remember you telling me that. I'm sorry about that.
So.
But I'm sorry.
They cleared those because.
But it was, again, forgery or fraud or.
It was just bad checks.
Bad checks.
Mm-hmm.
Okay. So there's a connection of basically fraudulent commercial paper checks, whether.
They were my own checks.
Okay. And that they were using, meaning your son and his girlfriend.
Yeah, the son and the girl. And I had police reports, several. If you look in the police report for Fulton County, it says when they sent out the BOLO that a guy sent, an officer sent, saying it back that I was a victim in his case. Because I had filed.
And you don't need to litigate those because they were dismissed. I just wanted to refresh my recollection of the legal landscape we've been working with. The Cherokee case. Bad title, you and an ex-boyfriend.
That's from 2014.
Okay, well, it's something significant because you got revoked for bunch of time.
For my first offense because of this charge.
Well, Cherokee is Cherokee. This is Fulton. We've got this case. We've got situations you're saying were with your son and his girlfriend. That's helpful to me. Do you want to consult with Ms. Wood any further before I do the final parts of this process? Questions or anything like that for her?
No.
Okay. Well, Ms. Honholt, I find there's a factual basis for your plea. And by that, I mean simply, if the jury went with what the state says the evidence is, a jury could lawfully find you guilty. I'm not saying they would. I don't know if they would. You're choosing not to find out. I also find that your plea is knowing and voluntary. Knowing means you understood everything we talked about. And I watched you. If you didn't, you said, wait, what are you saying? You are a very smart person. As you pointed out, you have a college degree. I think generically you understand the process. But if words were used that you didn't understand, you had us explain them. I also find your plea is voluntary. That does not mean you're happy about it, you're enthusiastic about it. What it does mean is that no one is forcing you to do this. You are deciding that this is how you want to bring closure. Because if not, like I said, I'm happy to give you a trial. You have decided to go forward trial solo, and I think wisely said, if you were to do that, you need a bunch of months, because it's not I show up on Monday and I'm ready to roll. And so you're weighing those options. You've got an absolute right to trial, force the state to prove its case, or there's this other opportunity that has presented itself, which is the case is closed today. And you are choosing option B. So I will accept that offered plea. It is not your admission of responsibility for this. I will follow I'm going to call it joint recommendation, what was negotiated, which is that I will sentence you on each of the 3 counts to 1 year to serve, and you will get credit for each of those 3 one-year sentences from that October 2023 date when you went into custody. There is no probation, there's no suspended sentence, it is 1 year to serve. And so by my understanding of the operation of criminal law, that closes out the case ending in 792. What's your birthday wish?
I just want to confirm that the 3 counts that you gave me a year on are all concurrent together.
Yes, ma'am.
You didn't say that.
Oh, I meant to. I thought I did, but either way, they run concurrently with each other, all at the same time. I have to give you a sentence on each of them. And that sentence is 1 year to serve, credit from October of 23, and they run concurrently with each other. So the total sentence is not 3, it's 1.
Okay, so my birthday wish. Okay, so being shipped back to where I came from, if I go back to Arundel, if they transport me, if you order that I be shipped back, I'll go back to Arundel first, and then I'll have to sit in lockdown. And I've never been in lockdown. I'm in the honor dorm, and I don't want to go to lockdown for 5 days until McCrae comes all the way to pick me up from Arundel back to. Is there any way that you can either order my transport on Monday, and I would only have to spend 1 night in lockdown, or if you could order me
Straight to McCrae.
Straight to McCrae.
So I can do close to that. What I can do is inquire of the GDC folks if there's anything I can put in a transport order that would make that happen.
It's not GDC, it's you guys. It's you guys that take me, not
I understand that it's Fulton County Sheriff's deputies, but they have to do what GDC says as to where we have Ms. Honholt, where should we take her? And they could say, take her to Valdosta. And they'd say, that's a male prison. Oh, our bad.
No, they'll say to take her to the Arundel, and then I'll have to sit in
lockdown for 5 days. So
no, I've never been to lockdown, and I don't want to go to lockdown.
I heard you say that, and you just told me you don't want to sit there for a bunch of days. So what I will do is reach out to my contacts in GDC to say, is there something that I can put in the final disposition or direct the sheriff's deputies to have this person who already has a space at McRae to go back to that space in McRae?
No, I know I'll go back to McRae no matter what.
Right, but you want to go directly to McRae. I understand your request.
They'll take me to Arundel and put me in lockdown as a sleeper until they have a bus to go to McRae.
Okay.
So that if Fulton County could transfer me, like say this Monday, I'll go to Arundel and then I'll only have to spend one night because then they do a transport on Wednesday morning Tuesday night at 2:00 in the morning.
Okay, but that's good to know. So I know that I have much more influence over what the sheriff's team does than what GDC does. And so ideally, you would like transport directly to McRae.
Ideally.
Okay, in a perfect world.
In a perfect world.
In a perfect world, you'd be at home. But in a closer to perfect world, straight to McRae.
Yes.
Failing that, dear Sheriff, please get Ms. Honholt to Lee Arundel on Monday.
Or a Tuesday.
Okay.
Tuesday would be great because then I would only have to spend 8 hours in lockdown.
Monday or Tuesday. That's a more likely outcome than a straight to McRae. But I will.
That's fine.
Okay.
Yeah. And then again, I usually stay here for a month after I'm sentenced.
Well, how would you know that if you haven't been sent? You haven't been sentenced.
A month
before.
after I come here, I'm sorry.
This is different because this closes your case out. With the other situations, it's look, she's in custody here, she's in custody there. Yeah, folks will move you when that's most efficient for them.
Okay.
We don't have a reason to hold you after I sign this document because 1 year has already passed. So I will work with GDC and I will work with FCSO to see if we can do either one of those.
Yeah, I just don't want to go to lockdown. I've never been to lockdown and I just don't want to go.
I'm hearing you.
I mean,
and for your birthday, we'll see what we can do.
all right.
All right.
Thank you.
You're welcome.
Happy birthday. Thank you.
Ms. Jackson, I sent you a chat, but I guess the chats don't pop up on your screen. That I was not going to be asking you about criminal history on Ms. Honholt, so you could go be free. I'm sorry you didn't see the chat.
Okay, thank you, Your Honor.
You bet. Thank you for being here. I think that's it. Thank you, Ms. Rivers. Ms. Williams, thank you. Thank you. Ms. Davis owes you whatever your favorite dessert treat is. She can give me some of it too, but I appreciate everyone for their work today. He didn't make it here. The cab and our sheriff's team